to mention item number 5, Lordship. Finally, matter may be fixed on 11 March. My senior Aziboro is not well.
Who is the senior counsel?
Aziboro.
She's not available today.
Yeah, no.
The request been made. The petition matter is it. In that case, we are listing after 2 weeks. We do want to any fixed date.
Yes, 11
Yeah.
months.
Hmm?
11 months.
No. Today you got to yeah, Germany 11 months is not possible. It will take will go after 11 March. 23rd of March.
Master.
May I please, Your Lordship? I pray for listing of an IA for orders, Your Lordship, on the 5th, Your Lordship, if possible. It was earlier allowed to be listed on 24th, but it did not come in the list, actually, Your Lordship.
5th, many matters are there. Maybe on
Can it be on 9th, Your Lordship?
9th.
May I please, Your Lordship? I beg to mention for listing of a bail application for hearing, Lordship.
Hearing.
On
Well,
Monday,
bail
Lordship.
hearing.
Bail hearing on Monday, Lordship. It was last listed on 11/2. It's a part-head matter before Justice PJ Sakia, Lordship. But
For justice,
PJ Sakia, Lordship, Honorable Justice PJ Sakia.
he is taking criminal best.
But the bench is available from Monday, Lordship.
Oh, from next week.
From Monday, it is available on
Monday.
Much of the Lordship.
May I please, Lordship, I pray for listing a motion matter, Lordship, on Monday, Lordship.
What kind of motion?
Criminal petition, Lordship.
Monday may not be possible.
Next week, any date, Lordship. There is some other thought.
9:30. 9th of March.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention for listing one criminal petition, Lordship, on 10, Lordship, 10 March.
Can it be? Okay.
I'm deeply obliged.
Lordship, I beg to mention item number 43, supply admission. 43, Lordship.
Yes, it was in admission column.
Yes, Lordship. Lordship, although I have prayed for listing this matter, Lordship, but a copy of the same has been received by me. I came to the information through the e-court service, Lordship. So give a direction to the petitioner to provide a copy of this petition so that I can file the reply, Lordship.
In that case, matter may be reached, then only order will be passed. Let the matter be reached.
Please, Your Lordship. Lordship, I beg to mention item number 33. This matter may be passed over for the day.
33.
33.
At the request made by Daniel Council for the 10th petition. List the matter be for the day. List according.
Please, Your Lordship. Lordship, I beg to mention item number 25. Lordship, kindly a matter may be adjourned for the day.
Yes, for the
25.
position of 25.
Should you receive?
Are you on interim there? Are they on interim?
Regarding that, there is no.
Otherwise, you have to retain the case right? That's 25.
Interim is not there.
So interim is not there. So you have to retain the case diary. Till when?
Yes, by not 9th or 10th.
Okay, 9th. Will be listed on 9th of March. We'll retain the case diary. At the request, because so and so. Is the matter of 9th of March. Retain the case diary.
May Lordship. Lordship, I beg to mention item number 40, Lordship. Actually, we have brought it by mentioning, but the petitioner side has some inconvenience, so otherwise also there is less chance of today hearing, Lordship, so some other date, Lordship.
Is otherwise you are for the petitioner or?
No, Lordship, we are for the respondent number 2. The petitioner side.
But have you informed the other side?
They have only informed us that today they have some inconvenience, so.
Oh, what's it? With the concept of the other side, and consider it's financial. You want here fixed date any?
Can be 10th March, Lordship, if possible.
It's a hearing date?
Yes, Lordship.
10th March may not be possible because there are some matters we have already.
But then any next hearing date, Lordship.
In that case, it will be on 26th of March.
Okay. There's some interim lordship that may be continued. There's interim order lordship that
Interim was there. Interim will continue till next day.
probably not much of
May I please? My lord, item number 12, I beg to mention it for today, my lord. One instruction.
Item number 12.
Yes, my lord. One instruction actually awaits, my lord, from the client. One instruction awaits, my lord. Small instruction we are.
From your client.
Yes, yes, my lord. So only a day of adjournment, my lord, may kindly be allowed.
This made by land council of petition matter be adjourned for the day list accordingly as amended.
My lord, a date may be fixed, my
No,
lord.
you adjourn for the day, it will be picked by the registry only.
See, my lord, on 5 May, 5th May.
Sorry, list accordingly.
All right.
Adjournment will be our- You are on item number 41
Yeah, fine. I am for the respondent, my lord.
in RSA. Acha. The appeal is dismissed as devoid of merit. Your second appeal stands dismissed.
Second appeal, 61.
It is dismissed.
Dismissed.
Yes. You are for a respondent,
Yeah.
goes in your favor.
Sorry for the inconvenience, Your Lordship. Lordship, I beg to mention a fresh listing of a fresh criminal petition,
It will be on 10th of March.
10 of March. Thank you, Your Honor.
May it please your lordship.
Mm.
Lordship, this matter was arised out of a CR case pending in the judicial Ministry first class, and that matter was dismissed due to non-prosecution by the prosecution by on 25th February. And that's why, lordship, this matter became in fact, that's why we are withdrawing this matter, lordship.
Otherwise, that matter was pending.
Yes, lordship.
Now it has been dismissed.
Yes, lordship.
You are MS?
Z Anjum.
MS Z Anjum.
Anjum.
MS Z Anjum. You're appealing for someone?
On behalf of Mr. M.K. Das, lordship.
Appearing on behalf of Mr. M.K. Das. Also heard Mr. B. Board, non-additional PP, appearing on behalf of state. It is submitted by MS Anjum that the original NI case has already been dismissed due to
Lordship, I have the order copy.
non-prosecution, and hence in view of this, the present petition has already become infructuous and accordingly should be for withdrawal. In view of this, petition is disposed of on withdrawal as rendered.
Deeply well, lordship.
May it please your lordship. Lordship, the petitioner was arrested on 6th February 2026 and as on date 21 days is in custody. Lordship, the case diary may be called for.
We call this demand. Yes, when it can be.
Oh,
That's
7.
from which place?
Polton was
Fulton Bazaar case.
Sultan was
on 13th of March.
13th of March.
Omnibus.
Wait, please, your lordship. Lordship, regular bail application, lordship, other co-accused petition fixed on lordship 5th of the March, lordship. This is the matter.
Other petitions.
Yes, lordship, this is the case, lordship. The person, lordship, Baharul Islam was picked up by the police. He raised hue and cry, Lakhimpur case, lordship. Now, yesterday, Baharul Islam was arrested from Gauhati, lordship. Now, all the
So,
cases,
the cases are fixed on 5th.
5th March.
Part Mr. Beachwater. The CDB call for let the matter be listed on 5-3. We are listing it.
Highly obliged.
Can you tell us one number?
All the numbers I have given in the lordship petition, there is all the
Just
numbers.
tell me one.
BA
number so that
5/2026,
BA
5/2026, another BA 57/2026. Highly obliged.
list along with BA 526 and 5726. Okay.
Highly obliged.
May I please, Lordship? 482 application, Lordship. Lordship, there is no FIR in this case. Police charged the petition on Unmati police station.
Why?
Lordship, on
There
10,
must be some reason. Yes.
On 10/2/2026, the petitioner was called by the police. And
2026.
yes, she was called by the police.
Mm.
And thereafter, she appeared before the police officer.
Mm.
But she was there more than 5-6 hours. Thereafter, police told her that you go to the home, and when we will call you, you appear before us. Thereafter, police visited her house, but no cases. She searched before the trial court.
Then do you have any kind of thing that why police is searching?
Yes, Lordship. There is a apprehension that one Swapna Borman,
Hmm.
who there is a dispute between Swapna Borman and the present petitioner.
Hmm.
So petitioner apprehension that Swapna Borman lodged any FIR against the petitioner.
Some dispute.
Yes, there is.
Call for the case. It is from
report-
Nunmati
A report may
station.
be called for
From Nunmati police station.
from Nunmati police.
You are Mr.
DCP, Lordship.
Heard Mr. D. Chutia, the learned counsel for the petitioner, and also heard Mr. P. Waterford. This is an application under Section 482 BNSS, paying for granted arrest bail with an apprehension for a case to be registered in under Nunmati PS police station. In view of this, let a detailed report be called for from Nunmati police station as to whether any case has been registered against the present petitioner in the said police station. The additional PP will do the needful, list the matter accordingly when
10th of March.
that.
Obliged.
May I please, Your Lordship?
Yeah.
My lord, it's an application
also
of 42.
same.
This one is also without an FIR, my lord. Disputable application of 482 of BNSS. My lord, there is no FIR, but what had happened, my lord, is that on 4th of February, my lord, police officers from North Bangladesh Police Outpost, they barged into the home of the two petitioners, my lord.
Huh?
The police barged into the home of the two petitioners, my lord, and petitioner number 1 is the father, petitioner number 2 is the son, my lord. And at that time, my lord, the petitioner number 2 was not at home, and the police asked about the whereabouts of the petitioner number 2, and even threatened the entire family, the petitioner number 2, that if the petitioner number 2 does not appear before the police on the next day and pay rupees 30 lakhs, then the police is going to arrest the entire family, my lord. And even took their PAN card and voter ID cards and everything, my lord.
This is done by police.
Yes, my lord.
But do you have any suspicion on anyone that someone
Not against
may?
anyone, my lord. We even, the wife of the petitioner number 2 even went to the police station and asked whether any police case has been registered against him. Police didn't say anything.
No, that I'm not saying.
Hmm.
These are the police from the police station who are visiting to your house, demanded money, whatever, these are
Yes,
there.
yes.
I'm saying, do you have any suspicion of any other person?
No,
that
my lord.
they may be in connivance with the police, they might have lost any case, or there is possibility of lodging any case. Do you have any? Such kind of things are not there.
No, my lord. We don't
Only
have
the
any-
police.
Only the police, my lord.
How?
This is why, my lord.
So I will have to verify them. I
Yes,
will
my
have
lord.
to get it.
Hmm.
Because otherwise in these days, well, in the name of police, well, some other persons also, well, there are cases regarding that. By pretending.
So
themselves
otherwise,
as
police
we-
directly will go to your house and demand it.
Yes, madam.
Bribery
We-
is there. I won't disagree with this. But there must be some reason that there is a case. It has to
Actually,
be,
regarding
otherwise we'll register
regarding
the
that,
case.
they can also lodge an FIR before the police
Yes.
station.
My lord,
Rather,
the
you could
wife
lodge
of
an FIR.
the wife of the petitioner number 2 went to the police station, asked them whether any case has been registered. They didn't say any. She even went to the Bangladesh courts, my lord, to check whether any court case has been pending against the two petitioners,
that
but there were
notice.
none.
Regarding
we'll
my
give
lord,
a short
verbal
letter.
inquiry will not do, my lord. They will have to submit a written my lord, FIR before the police station.
But some
Yeah,
protection may kindly be given, my lord. Otherwise, some protection may kindly be given. My lord.
Now, that's why I'm just repeatedly asking you, do you have any, is there any possibility of case?
Yes.
There may be something, that some possibility is there.
My lord,
But
the,
without anything, how police will demand you 30 lakhs? It just seems to be a bit. Otherwise, I can understand that there
Yeah.
are many cases where the police demands money and all, not to register a case, not to do, and so these kinds of things are going on. That is understood. That is okay. But without anything, how police will go and that to demand will 30 lakhs? It's quite absurd. List.
my lord, the,
Let the report be called for.
Yes.
my lord,
You are Mr.
S.H. Mahmood.
Heard Mr. S.H. Mahmood, the learned counsel for the petition. And also heard Mr. P. Waterford, the learned additional PP, appearing on behalf of state respondent. This is an application under section 482 BNSS. for granting fair respect to the petitioner with an apprehension of registering any case against these two petitioners. Under which police station? You have not mentioned.
Not Bongaigaon Police Outpost.
Not Bongaigaon.
Bongaigaon Police Outpost and Bongaigaon Police Station.
Under
Both
Bongaigaon
might,
Police Station.
yes.
Not Bongaigaon Police Outpost, under Bongaigaon Police Station. Let a detailed report be called for from the North Bongaigaon Police Outpost under Bongaigaon Police Station as to whether any case has been registered against these two petitioners, either in North Bongaigaon Police Outpost or in Bongaigaon Police Station itself. The additional PB will do the needful. When it can
On 11/3, my lord.
will do
It's
11.
a long date, my lord. Till then, some protection may kindly be granted.
Sorry, no protection. Case is not there. How can we protect?
On 6/3.
6-3, okay.
60 will do.
6-3.
60. I'll take that. This is by NCB, na?
Yes.
None appears on call for the petition.
In fact, their name also not shown. Oh, yes, NCP has filed.
NCB has filed, yes. You know,
Petitioner.
none appears on call for the petition. The matter be listed after 2 weeks as on the date.
Leadership.
Is it given out? Ali 25 or Asil. Ali given out. Chandra like a Yes, yes.
My lord, this is we have a challenge in order, my lord, which is page operative part is page 36, 37, my lord, whereby
36,
maintenance.
37.
Yes, madam.
This is the order.
Yes, madam.
Ah.
36 is that is 13.1, my lord. So here the maintenance amount has been imposed on rupees 8,000 on me, my lord. I have challenged this amount because of the fact that, my lord.
No, earlier it was 12,000, now modified
Yes,
to 8,000.
yes, modified this. Well, why I have challenged is because in my case, both as a husband and myself, both the wife and myself, both are employee, government employee. She is staying in her parental house with the child, no doubt. But in our assets and liability certificate, which I have annexed here, here it is clearly proved that she has no burden and she is getting 32,000, and whereas I am also about the same amount. I am also getting salaries. But Planet Code will.
How much she is earning?
She is earning 33,000 or 32,000 something, my lord. It is admittedly she in her statement assets and liability.
She is a government employee.
Yes, I am also a government employee, but Planet Code below did not consider this fact because I have also EMI. I have old age mothers which I have to maintain this. This fact has not been considered at the time of imposing this amount on me only. Where is this a settled principle of the law, my lord? Supreme Court?
Who will provide the maintenance to your child?
Court ordered me to.
No, you.
Yes, my lord.
Rest she is bearing. Now your child is there.
Definitely, my lord.
Only or with you?
But the Supreme Court settled principle law is
whatever. With
yes,
the child is with you or with her?
with her.
Then who will maintain her child? The child.
My lord, the
Is it
amount
not your responsibility to maintain?
definitely both Supreme Court says
No,
both
with
responsibility.
her. Now I'm saying you are not responsible for your maintenance.
I'm not saying this amount. I am not saying this amount. I will not pay. I am saying this, my lord, as per Supreme Court decision, my lord, this amount to be 50-50, my lord. Since she is earning in Neha versus judgment, my
Yes, the Neha versus is okay.
yes, my lord. So here this, since I have the burden, my lord, she
So
she has
you moved the appeal.
yes,
I mean, application.
yes,
So it has been modified, rightly modified
yes, my lord.
from 12,000 to 8,000.
8,000, my lord.
Then
Now this 8,000, my lord, I have no problem, but this since she is also earning, my lord, and I have all the EMI and other
okay,
burdens.
issue notice there.
Yes, my lord.
Your EMI is that you have some loan for your construction of houses and all these are not come, na?
But I have the my yeah, your lordship. I have
What
also
your,
the rest.
what your child is doing now in which class?
4 years, man.
Only 4 years.
Yes.
This maintenance, what was the order? Maintenance for your wife or child?
For child only, my lord.
Yes, that's what I'm repeatedly asking. It is for child, not for her.
Definitely, my lord.
Not for her. Remaining, she is bearing. She is bearing the remaining amount of his or her expenditure. Okay, hard you are Mr.
A.Y. Chaudhary.
Hard Mr. A.Y. Chaudhary, Dilanit. T.A. na?
A.Y. Chaudhary, my lord. I'm on behalf of
A.Y.
him.
Chaudhary. Acha. On behalf of T.A. Chaudhary.
Yes.
A.Y. Chaudhary, appearing on behalf of
Diana,
A. Chaudhary, Dilanit counsel for the petition. This is an application.
गलत ना से नहीं
This is an application
गलत मत
for
limiter है
438 of the 442 BNSS related to section 227 of Constitution of
Designated
India
alia.
against the imprint judgment and order dated 8/01/2026 passed by Learned Additional Session Judge Hailakandi, Tribunal Appeal number 04 of 2024, arising out of order dated 8/01/2025 passed by Learned JMFC Hailakandi in DB case number 57 of 2021 to 21. Next para, issue notice to the sole response to speed post and usual process. Also call for a TCR. Let the matter be accordingly listed. When your next date is fixed, can you tell us?
My lord.
Do you have any idea next date is fixed for your payment? It was the case was passed in under DB case.
Yes, under DP.
Anyway, after 2 weeks will do. 2 weeks will very short, I think.
3 weeks.
Come, 3 weeks. List after 3 weeks. Take immediate steps on it. Now tell us one thing. Till date, have you paid anything to your child?
Child, my lord, just order pass, my lord. I have still.
Order is passed in 2025. Now it is 2026.
Yes, my lord.
Now see your conduct. Huh?
Earlier,
The order is, listen, your order was passed on 8/01/2025. Now we are in, I mean, about to be March 2026.
yes, my lord.
Till 1 year, you have not paid a single penny to your child. Now you are seeking the 8,000 is also very big amount for you. Isn't it?
Not big amount, my lord. I am only on that point that responsibility should be both, my lord.
Yeah, she is bearing the responsibility after 3 weeks.
Oblige.
Okay.
May it please your lordships. My lord, revision against order of maintenance, my lord. Yes, my lord, I am liable to pay maintenance to my child, my lord. And my lord, learned trial court was kind enough to not award maintenance against my wife, but only to my child. My lord, the problem is that I'm a patient of severe schizophrenia, my lord. Lordship may kindly peruse page 15 and 16. And since 2015, my lord,
Now, if you're the disease of schizophrenia, what are you doing now?
my lord, I am dependent on my father, my lord.
Where is the schizophrenia?
My lord,
Existence and
page 15 and 16.
So you are having medicine now?
Yes, my lord. Lordship,
Now
if I may suggest one thing, my lord.
Huh?
Lordship may remand the matter to the learned trial court to actually verify whether what is the percentage of my illness and all, to properly appreciate the evidences, my lord, regarding my mental illness. Lordship may dispose it of, my lord.
What was the amount?
2,500 only, my lord.
Very big amount.
Yes, my lord. True, my lord. Since I am not earning a single penny, burden will be upon my father only, my lord.
At the time of the discussion in while passing the order, is there any discussion regarding your?
Yes, my lord. In my evidence, it is there regarding my mental illness, but that was not considered in my lord. Only in brief it is stated, my lord. For that reason, my lord, I am submitting, my lord. It may be remanded back to properly appreciate the evidences
If
regarding.
it is already there, then too we cannot say anything now. You have submitted your plea of illness. You have already taken. That has already been discussed by the learned trial court. Evidence is also adduced in that regard.
Discuss, my lord.
So that has
But my
been
lord,
discussed, right?
these my lord, mental illness, if their officials are being, the evidences of there are taken, my lord, then it will be properly, my lord. Whether actually I am supposed to or my
Is
lord,
there any denial to that?
regarding my
That
lord.
now you're a schizophrenic patient. Is there any denial to that? That you are
No,
not?
no, my lord, no, my lord. And
It's not
probably
there.
that is the reason my wife has left.
Not there. Obviously, you have a ground. You are now dependent. So when the order was passed?
My lord, 17/11/2025, my lord, recent order.
Then do one thing. We're not before remanding it, or we are issuing notice to the other side.
Lordship.
Let them appear. If matter can be sent before mediation or before in the court itself, it can be settled. Then it will be good only, because your medical illness, etc., are already been discussed and decided by the learned trial court. But apart from that, there are some reasons, because you are the father
Yes, ma'am.
and wife who is not there anyway, is not allowed. But it can be fully exonerated from your liability.
Like, yes,
It's
ma'am.
okay.
That is true, my lord.
See, wait. You are Mr.
A. Choudhury.
Card, Mr. H.O.D. State is a formal party here, and
No, my lord.
it's an application on section 4 of PNSS for setting aside and quashing of the judgment and order dated 17/11/2025 passed by learned principal judge family court board criminal in criminal case number 612 of the group. Issue notice to the sole respondents to speed post and usual process, and also call for PC. Let the matter be accordingly. 2 weeks may not be sufficient. Let it be on 3 weeks.
Lordship.
After 3 weeks, as an edited. If they appear, you can discuss the matter and settle them.
Lordship. My lord, this order is stayed, my lord. 17/11.
Oh, acha, your order, na? Till next date of listing, the order dated so and so is state. Okay, please.
Obliged, highly obliged.
May I please, your lordship. Well, this is a quashing application. I have prayed for quashing of the charge sheet and all consequential proceedings thereof. But before proceeding with the facts of the case, I'm just giving a brief background, my lord. In 2013, the complainant entered into an agreement with a co-accused for a larger tract of land on a particular village and Moja. The village was Santola village and the Moja is Chayani Moja. Well, pursuant to that agreement, the agreement holder entered into an agreement with the petitioner with a smaller portion of land out of the larger tract of land. Now, the larger tract was 86 bighas and the smaller tract was 5 bighas. Now, in respect, I have entered into a registered agreement with the co-accused. Subsequently, my lord, that area was taken under acquisition by the state, because of which I could not perform the contract. And thereafter, my lord, through a registered agreement for cancellation, I cancelled the agreement and I returned the money through bank payment. And subsequently, my lord, through bank, that money was paid to the agreement holder, and in turn, my lord, the agreement holder returned the money to the complainant. And these are all from verifiable record, which are not forming part of the case record after investigation, although I had produced it before the IU. Now, my lord, these are the incidences which had occurred prior to the registration of the FIR. So, my lord, the FIR was registered in 17th of December 2015. And prior to that, my lord, all these incidents had already happened. So these are predated to the FIR, my lord, incidents. Now, my lord, the only question, my lord, whether the court under 482, my lord, is empowered to look into the documents at this stage after filing the charge sheet, which are relied upon by the defense, by the accused persons, which are not forming part of the case record. My lord, in this regard, my lord, there are three decisions, my lord.
Decision will see later.
My lord.
Now, what is your case now?
My lord, my case, my lord, that
is
so
the
far
FIR?
as this allegation is concerned, my lord.
Where is the FIR?
Yes, my lord, I am coming to that FIR. The FIR is at page 31, my lord. May I proceed, my lord? My lord, this FIR is dated actually 7/12/2015, which I could find out from the case record in page 32, my lord. The date is not mentioned in page 31. I, on behalf of All India Service Officers Cooperative Group Housing Society Limited, Gauhati, would like to inform you that we had made an agreement with one Sri Sautik Goswami, son of so-and-so, resident of so-and-so, who was supposed to provide us a plot of land measuring 86 bigha, 3 kotha, 10 lesa for construction of IAS, IPS, IFS colony in Mauja Chayani. My lord, kindly mark Mauja Chayani in the district of Kamrup, Assam, and an amount of 3 crore 60 lakhs were paid in advance. As per the said agreement, Sautik Goswami had to hand over the said plots of land within 3 months from the date of execution of the deed of agreement dated 11/10/2013, but till date he has failed to do so. Now, this is the agreement so far as the complainant and the co-accused is concerned. I am nowhere concerned, my lord. Later on, he returned rupees 50 lakhs only on 28/7/2014. My lord, kindly mark this date, 28/7/2014. And in order to return the balance amount of 3 crore 10 lakhs, he issued number of checks over a period of time, and all such checks have been bounced. Check number so and so, my lord, I'm not going into that details. My lord, the next para, recently on 11/9/2015, Sri Sautik Goswami issued 3 checks by check number so and so, dated so and so, of Central Bank of India, Gauhati branch, amounting 3 crore 10 lakhs, only which were again dishonored by the bank authority due to insufficient fund in his bank account. Lastly, just to buy time and convince us about his efforts in making arrangement of money, one day Sautik Goswami showed a copy of draft of 4 crore 70 lakhs only issued by Central Bank of India in the name of Heidelberg India Private Limited, a company from which more than society's due amount is payable to him. During cross-checking with central bank dispute, it was found that the bank authority had not issued any demand draft amounting to 4 crore 70 lakhs only in the name of Messrs. Heidelberg India Private Limited. This aspect has not been dealt with by the IO and it is not in the charge sheet. Thus, for the last 2 years, he has made us to understand that the amount so received from us shall be returned within a short period of time, and that by way of false assurances, he has been delaying the payment of the amount received in advance, and we apprehend that by taking away entire amount, he might settle down outside India along with his entire family. The society is under tremendous pressure from its members for refunding back the money to its members. Sir, many a times we requested his father so-and-so and mother so-and-so to ask Sautik Goswami to return our money, but they have also been giving false assurances and have not paid the money till date. We have also learned the following persons. Now, here is how I come into the picture, my lord. We have also learned that the following persons in criminal conspiracy along with Sautik Goswami have committed similar fraud and swindled money by resorting to various fraudulent and illegal means and are a party to the present case also. But my name is appearing in serial number 2. Next para, my lord. It is abundantly clear that all the above named persons had jointly hatched a conspiracy to siphon off such a huge amount by entering into a fraudulent deed dated so and so for their illegal financial gain, inducing us to pay that amount, and as such they should be immediately booked under the appropriate provision of law for the criminal offense. Now, that agreement which has been referred 11/7/2013, I am not a party to that agreement, and the charge sheet is, my lord, at page 32, my lord, relevant portion 32. This is the typed copy, my lord.
This is the FIR 32.
My lord, this is the typed copy of the charge sheet, my lord. Page 32. 3 is the annexure 2, my lord. FIR type copy is at page 27, my lord.
Okay.
My lord. My lord, may kindly come to page 34 once. The brief history of the case, this is I am reading from chart sheet, my lord, type copy.
Okay, B50 is there where this Swati Kusami's name is there and all.
Yes, yes, my lord. My lord, and so far as my lord, kindly come to page 50, my lord, once. Page 50, 51, my lord. 51 is the agreement for sale, my lord, which I had entered into with Swati Goswami. And this is a registered agreement for sale, my lord. And if my lord kindly turns to page 53, my lord. Page 53, second para, whereas the first party is the absolute owner and possessor of the land measuring 5 bigha, 1 katha and 18 lesa. And my lord, kindly see the dag number is 770 and 769. This is the specific agreement which I had entered with Swati Goswami. And revenue village is Santola, Moja, Chain. And my lord, subsequently, my lord, at page 59, my lord, I had cancelled this agreement because of acquisition proceedings, which I have also annexed. My lord, kindly turn to page 61, my lord. 59 is the cancellation agreement, my lord. Registered. This is also registered, my lord. Page 59. And my lord, 61 is the schedule, my lord. 5 bighas, 1 katha, 18 lesas covered by dag number 770 and 769 of village Santola and Moja Chayani. So, my lord, I had cancelled this agreement, my lord, because, my lord, the entire area was taken into acquisition by the government. And my lord, kindly turn to page 65, my lord. Kindly have page 65, my lord. So this is the certificate issued by the Deputy Commissioner's office, my lord, so far as the acquisition is concerned, certified that the land, my lord, has 65, my lord. My lord is having 65, my lord.
During investigation, many things revealed against you, and those were there in the charge sheet itself.
My lord.
What are the ingredients against you, for which the charge sheet was also filed against you?
Yes.
Yes,
My
Dr.
lord.
Goren.
Yes. Page 37, my lord, regarding the search during investigation, what are the materials against the present accused person, my lord? And regarding the agreement, my learned friend has shown to your lordship, that is the agreement between my lord Totik Goswami and those, my lord, IS officers, my lord, retired IS officers, my lord. Regarding total plot of land, my lord, as per that agreement, Mr. Sotik Goswami has to provide them 86 bigha, more than 86 bigha. And the agreement between Sotik Goswami and the present petitioner is only a small portion, that is 5 bigha. And regarding other portion of land, my lord, how these accused persons came into the picture, my lord, how he helped Sotik Goswami to acquire, my lord, those large portion of land from the original landowners, my lord. Regarding that aspect, my lord, page 37 of the search sheet is very clear. by obtaining, my lord, power of attorney from the original landholders, how they help, my lord, Sotik Goswami to acquire those huge portion of land, and thereafter, my lord, they in fact, my lord, involvement, Sotik Goswami has although, my lord, returned a small portion of money, that is 50 lakhs, out of that, my lord, more than 3 crore. Otherwise, there are, from the search it reflects there are materials against the present victim.
You will call for this one.
My lord, for
It is not at all a case for any stay of the proceeding against your.
No, my lord, I am not paid for any stay, my lord. In fact, this case has been stayed, my lord.
Already
Kindly
stayed.
have page 86, my lord. Sautik Goswami had filed a criminal petition, my lord.
Hmm.
And by order dated 4/12/2024, my lord, a coordinate bench of this honorable court has already stayed this case.
only that is.
And my lord, I have not prayed for any stay, my lord.
Oh, it is already stayed.
Yes, yes, my lord.
No,
It has already stayed, my lord.
Sautik
Case
Already
is
stayed, my lord.
stayed.
Yes, my lord.
Oh, acha.
My lord, that is, my lord, although may not be only in respect, Sotik Goswami has filed that criminal petition.
No, but the order doesn't say so. You see the order? At page
But therefore, it is hereby directed that the further proceedings in PRC case number
Yes,
so and so
yes,
pending
and
so and
like
so
this.
stayed. And my lord,
So
I have
now
not
stayed.
prayed for any stay also, my lord. There is no prayer, my lord.
Scan copy of PCR.
So what is the stage of the case at present?
My lord,
Charge has already
supply
been-
of it has been stayed, my lord. The 207 stage has not been reached, my lord. It is pending for supply of documents, my lord.
Still pending for supply of
Yes, yes, my
documents.
lord. And my lord, at page 77, my lord, there is a judicial finding, my lord. So far as the allegation is concerned, my lord, that may be examined after the detailed affidavit is received from the court.
This matter may also kindly be tagged with that criminal petition, ma'am.
Yes, obviously, it will
Yes.
be helpful. In that.
629/20.
6? Criminal petition 629.
Yes, yes, ma'am.
You are Mr. S. Das?
Yes, my lord.
Hard Mr. S. Das, the land for the petition. So hard. Mr. P. Bought good in an petition, being on chips. It's an application of 628 BNSS. Rate restricted 482 BNSS for seeking washing of with number 134 of 2024, dated 29/02/2024, rising out of persistent police station case number 1408-15 under section 120, 406, 409, 420 IPC, and the consequential proceedings in PRC case number 209/2024, pending before Court of Granite CTM Kabul. Issue notice to the respondents. No formal notice is through speed post and usual process. No formal notice is required to be served on the petitioner state respondent number 1. However, copy of the petition may be distributed to court. Scan copy of the TCR along with the case diary be called for. List the matter. Your next test is listing. List the matter after 4 weeks as on a date to be fixed by the registry, along with CI criminal petition number 629 of 629 of 2024. We're listing it along with 629 of 2020.
My lord. My lord, then in that case, my lord, because this notice has to be served, my lord. So on the next date of listing, my lord, if it is tagged, then it will be convenient because otherwise the process will get entangled.
Okay, then no need.
Yes, yes, my lord. So far
After
as
4 weeks. Okay, we're listing it up.
yes, yes. Deeply obliged.
People. Time.
Ma'am,
Yes.
my lord, the petitioner facing trial in a fake gold case, my lord.
Mm.
And now NBWA issued against him, my lord. The order sheet, my lord, I have annexed. My lord, kindly peruse page 25 first, my lord.
25.
25.
Yes.
Lordship has page 25, order dated 14/8/2025. After 3 lines, my lord, accused Ashadul Haq and Bilal Hussain are absent. Summons issued to them not yet returned. Issue afresh. Then, my lord, 25/9/2025. After few lines, my lord, accused Motibur Rahman, Ashadul Haq are absent with steps, by petition number so and so, respectively. Heard, learned counsel, prayer is allowed. Then, my lord, on next date, 30/10/2025, my lord, kindly turn to page 26. Accused Motibur Rahman and Ashadul are absent without any step, issue NBWA against the accused person. My lord, on that day, my lord, what happened? The learned engaged counsel, my lord, he informed the petitioner, but on the day of 30th of October, my lord, during the court hour, my lord, he informed that today is the date fixed, my lord, you come. My lord, I was in Arunachal Pradesh, my lord, I could not come. And the next date, my lord, he did not inform the petitioner. My lord. That is the case, my lord. Now I am aware, my lord, I want to contest the case. I am ready to face the trial, my lord. Some protection, my lord, on the next date is fixed, my lord, on
Then what is the order of 10/12? 10/12 issue notice was issued.
10/12, my lord. 10/12, my lord, page 27, issue PNA and NBWA against him, my lord. My lord, I could learn about the NBWA only on 14, my lord. I have stated in para 4. It continues to page 5, my lord. Lower portion of para 4, my lord. The petitioner could learn about the NBWA on 14/12/2025, and he immediately applied for certified copy on 15/12, and same was delivered on 17/12. In the meantime, on 10/12/2025, PNA and NBWA has been issued against it. Now, my lord, next date, my lord, 8th of April, my lord. My lord, at any condition, my lord, I may be allowed to appear before the learned trial court, my lord. I am
In the
ready.
charge sheet, you were shown as an absconder or no?
No, my lord.
You were on bail.
I am named in the FIR, my lord.
So named in the FIR is okay. You are on bail.
No, my lord. My lord, just a minute, my lord.
Well, otherwise, he stated that only on 14/12/25 it came to notice that, my lord, regarding the pendency of the present case. But in page 25, on 25/9/25, he has, my lord, filed petition before the trial court.
No, that he most probably admitted that through his counsel it was filed. And next day was 30, most probably 30/10/2020.
Yes, 30/10.
Wherein his petition.
My lord, absconder, my lord. Absconder.
Oh, absconder.
Absconder. Page 19.
Yes, but
Page 19.
Page.
19.
Let him appear before, my lord.
you are Mr. Khan.
M. Ali.
Mr. M. Ali, and counsel for the petition. Also, Mr. What? Against him in order to 30/10 filed by learned GMFC in PR case number 429 of 2025, whereby non-bailable warrant of arrest has been issued against him for his non-evidence and straight for subsequent submitted to Mr. Khalid, the defendant petitioner, was ready and willing to appear before the learned trial court below trial. And he, after receiving summon, he engaged in counsel, who also took steps on his behalf on 25/9/25, and that next date was fixed on 30/10. But on 30/10/2025. It was not, but the next date was not intimated to him. And immediately on 30/10/2025 itself, his and his counsel asked him to appear before the Internet Trial Court below. But he could not appear before the court as he was in Arunachal to earn his livelihood. There, when he came from Arunachal, he only came to know about the issuance of warrant against him on 14/12/2020 and 14/12/30. However, the petitioner is ready and willing to contest the case by appearing before the trial court below if he is provided with some information. Next, Mr. Bot, the petition will be submitted in this that the one chance may be given to the present petitioner to appear before the learned trial court below with an appropriate application for bail, which may be considered. Next, hearing the submission made by learned counsel, considering all other aspects of the case, the petitioner is hereby directed to appear before the learned trial court below within 15 days from the date of order, and date of order with an appropriate application for bail, which may be considered in accordance. However, till 15 days from the date of order, the NBWA and PNA issued against present petitioner be stayed of the above observation.
I'm of that one. Highly of.
The petitioner before lordship for quashing of the CID PS case number 9 of 2024 and the charge sheet lordship. So what happened in the case lordship? The petitioner is a police officer, retired police officer. While he is working in the Vigilance and Anti-Corruption Department, he was entrusted in a case lordship, and he submitted the charge sheet in the case. After that, the special court, after trial of the publication of trial, his accused has been acquitted. After that, the department lodged an FIR before the CID against the petitioner. He already retired from service lawsuit and submitted charge sheet lawsuit. That is the case lawsuit.
Why? What was the allegation against?
Allegation is that the alleged that the IO, the present petitioner did an IO, have not sent the voice sample to the FSL. But actually, what happened, lawsuit? He has sent the voice samples to the FSL, but it was returned back by the FSL that due to non-availability of the equipment lawsuit. And in Vigilance and Anti-Corruption case lawsuit, the OC, SP is the OC. As a IO of the case, the present petitioner forwarded the voice sample to send it for the Chandigarh for re-verification. But it was not done by lead and SP and officer incest. That is the case lawsuit. And what happened in the case lawsuit, in a special case, 20 witnesses has been cited as the PW. Out of 26 witnesses become hostile, even the informant also. For which the learned special court acquitted the accused person. That is the case.
Yes, my lord, I will point out, my lord, regarding the present petitioner is IO of that, my lord, case in which, my lord, one Bhupesh Das was acquitted by the trial court later. And regarding the present case, the present case is CIDPS case registered against the present petitioner, and allegation that he is responsible for, my lord, purposely, my lord, designedly made defective investigation and ultimately which helped the accused to get acquittal, my lord. And regarding that, your lordship may kindly come to FIR at page 27.
27 is the FIR.
At present, my lord, in that earlier case wherein Bhupesh Das, he was the earlier CEO of the, my lord.
FIR, you're pointing out FIR.
Page 28, my lord.
28.
Page 28. Your lordship may kindly come to page 27, last paragraph. It was found in course of inquiry that the investigators have seized one Samsung AS A5 handset with one SIM card having mobile phone number so and so, where the conversation involving Sri Bhupesh Das, ACS, the then CEO of Dorong Jilla Parishad, and the complainant Sri Tiharu Gaur with Sri Nolini Sohoria and Sri Abdul Latif Mondal on 21/9/2017 was recorded. the aforesaid mobile handset along with a micro SD card containing voice samples of the complainant Sri Teharu Gaur, the then ZPC member Lalpur Jila Parishad, Sri Nolini Sohoria, the then ZPC member so-and-so, Sri Abdul Latif Mondal, the JPC member so-and-so, and the accused Sri Bhupesh Chandra Das, the then CEO Dorong Jilla Parishad, who was the accused in that case, wherein the present petitioner is the IO, was sent to the Central Forensic Science Laboratory, Kamrup, by this directorate letter number so-and-so dated 6/10/2017 to compare the voices in the question audio file in the mobile handset with the voice samples collected and sent in the micro SD card. The director CFSL Kamluk returned the exhibit sent by the aforesaid letter and intimated this directorate by letter number so-and-so dated 10/10/20 that the said case could not be accepted due to non-availability of instrumental facility for examination in the laboratory, and further suggested, this is to send the same to the CFSL Chandigarh, mentioning address of the same for examination and comparison report. The said letter of the director CFSL Kamrup was received at this directorate on 2017, and then the then SP Law DBNSC Assam directed to hand over the same to the IOC, the present petitioner, my lord, to discuss with SP DBNSC Assam. Accordingly, the letter was handed over to the IO, the present petitioner. Then the then Inspector of Police Assam, who duly received the letter on 12/10/2017. From the available records, it is found that no follow-up action was taken by the IO in respect of sending the exhibits to CFSL Chandigarh for comparison of the voices present in the audio clip with the voice samples of the persons involved in the conversation. Instead, the final progress report of the case was submitted by the IO, the then Inspector of Police, without mentioning about the pending task of voice comparison. Instead, the IO opined in his final progress report that a prima facie case had been well established against the arrested public servant Sri Bhupesh Chandra Das, the then CEO, Dorong Jilla Parishad, Mongoldoy, Assam, under section so-and-so of the PC Act 1988. After that, the charge sheet of the case was submitted by the present petitioner by CS number after getting the prosecution sanction order from the competent authority. So, my lord, without sending that CFSL report to the, my lord, Chandigarh, or my lord, and without even, my lord, mentioning anything in the charge sheet that why that, my lord, CFSL, that, my lord, forensic evidence has not been sent to the, my lord, CFSL Chandigarh, and there is no note in that regard in this charge sheet. And thereafter, my lord, after that FIR, my lord, inquiry, my lord, charge sheet submitted against the present accused, and my lord, during, my lord, at the time of during investigation, there are some materials finds against the accused that this petitioner is my lord, has deliberately, my lord, has not sent that, my lord, forensic evidence to the CFSL, and which is vital evidence for, my lord, convicting the accused, my lord, the CEO of that at that point of time. In that case, ultimately he got acquittal for, my lord, not having sufficient evidence because of not sending that, my lord, forensic evidence to the CFSL without for. So this is the case. So ultimately, after, my lord, filing the FIR, my lord, investigation completed, charge sheet also filed against the finding materials.
Also, as the IO of the case, Lose, in the Vigilance and Anti-Corruption Department, SP is the OC, Lose. And the IO cannot send it to the Chandigarh also. The present petitioner requested the D then SP to Superintendent of Police,
Was
Mr.
there
Anand
no
Mishra.
It's okay. You have some case then. Though it was informed to SP so and so, but
It was
at
not
that
sent to
time
the
he was not sent. It was not sent to CFSL Chandigarh.
Chandigarh.
Now, but the question is that those things which should have been reflected in your in your charge sheet or at the time of inquiry, you should have reflected all these things. But these are not there. Now you're saying that it was the duty of the SP. Yes, maybe it's
Already
a duty
he
of the SP.
forwarded the SP.
Oh, then.
But did the SP then says that?
Then he could could have waited for the coming and all day. You could have inquired about the matter with the SP regard
They also
that whether
SP
the sample
directed
has
them to
already been
submit
sent.
the charge sheet.
But
Accordingly,
without
submitted.
doing anything, you have just simply came into a conclusion there are sufficient matters and you have already charged it because voice sample is very important for this, especially in corruption cases.
But
If there is any telephonic
in
conversation,
the hospital, in the trial court, no, he stated that due to the scientific evidence, it was acquitted. Only
that I don't know at this stage. How can we say now?
so this trial court, no, he stated. He that only stated that.
Okay, then whatever, we'll see to it.
So I pays for stay of the proceeding.
Stay. Okay, this case. What is this case at present?
For appearance.
For appearance.
And
Charge, I mean, charge is yet to be framed.
Notice that someone has been issued the present
I
petition.
can
He
understand.
had to
No
appear.
charges not yet.
Not yet.
So here I think for to that issue, the case record of the earlier case record will also be required or what? If there is any note as per him, I don't know.
Yes, ma'am.
The office note of the vigilance is required, but because the petitioner noted in the office note, it was not sent by deed and SP. It is the case.
Where from we will get these things?
Vigilance and Anti-Corruption Department.
No. Vigilance Anti-Corruption Department enter case. Now this case record in the case diary of the earlier case, which
Yes,
was
special case
submitted
required.
by you, that has to be called for or not required.
Well, at this stage only that the present my lord scan copy of PCR may be called for ma'am. During that.
Then later on we'll see.
Petitioner retired also service from the 2010 and they still have not filed any appeal in this case, whether against the acquittal order, as per my information.
Well, as per my instruction, my lord, probably my lord, state has also filed my lord, appeal.
And the filing of this petition will charge no appeal has
But
been
regarding
deferred by
that
the
aspect, my lord, whether state has any but till now, my lord,
order
I
is
will provide the information.
Now see, to file an appeal also, there has to be something, isn't it? Now, if your inquiry, during investigation in your charge sheet, there is no such materials on the basis of which the state can file an appeal, then may not be a reason to file an appeal. Because your inquiry or the investigation is stated to be defective and it was designed.
That is
by you.
allegation. That is
the allegation. That's what I'm saying. If that is the allegation, then what is the purpose of filing an appeal also? In appeal also, there is a probability, very less probability of the succeeding the appeal.
And last
That may be one of the reasons. I don't know.
the judgment was passed on in the year 2023. FIR, they lost the FIR in the year 2024.
Which FIR?
Against the present petition.
Against you.
Yes, Lordship. In the year 2024, 11/7/2024.
Regularity. You cannot
After
calculate
1.5.
these things within 10 days, 15 days.
Yes,
It is not there because it is subsequently it has come to the department light. It has come to the light of the department that these things are happened for that reason that person got acquitted. Maybe the actual reason may be
otherwise my search sheet, my search not yet framed. Let him place all these materials at the time of framing of the search, my lord.
We can pray for it.
Kindly call for the record till then. Kindly stay the proceeding.
No, stay. If this kind of case is taken, you are Mr. Gogoi?
Yes, Lordship.
Hard Mr. N.J. Gogoi, the Garnet Board. The learned additional PP appointment. An application under Section 528 PNSS. Bring for portion of the FIR dated 11/7/24. Registered at CID PS case number 09/24. Under Section 166 A, capital A, bracket of small b, object 2017, slash 2018, slash 2000, sorry, 2000, no, 207, 217, 218, 201, IPC, read with section 98, small a, of Assam Police Act 2007, 7, corresponding to GR case number 4051, 2020, and PRC case number 2394/2025, along with the charge sheet number 03/2025, dated 09/4/2025. Filed against the present. Who are the the respondents? The
Respondents
Manoj
are
Kumar.
the informant, who is the informant, other the inquiry officer, on the which basis the FIR has been lost, other two also IO lost.
So I suppose
My
you
lord,
cannot appear for all these
at this
items.
point of time, your lordship may kindly issue the notice because my lord, probably he has made some allegation of personal, so my lord, some personal allegations also.
No, we have not any personal allegation. I make them party only because they are Manoj Kumar Das is the informant. And
Well, at
but
this
then
stage, only notice may be
notice
issued.
will be
If
issued.
later on required, I will represent them.
To the then also for the scan copy of this here along with the case diary. No formal notice is required to be stated. But copy of the petition be served in court. Can you tell us when your next date is fixed?
10th of March.
10th of March. But prior to 10th of March, probably it may not be possible.
So also till then.
You're not going any stay out. But 9
On that day, he can also take adjournment. And thereafter, also your lordship may fix.
yes. You can take the brief of discharge also.
Yes.
Which way you can't take
24th of March.
yes, 24th of March.
Obliged.
Lordship matter may be taken up after some time. 13 and 14 also. Senior is on late lordship.
Both are of same FIR or different cases?
A different case.
Achha. Both 13 and 14?
Yes, both are. My senior will appear.
Wait,
Yes.
Lordship. Lordship, the senior counsel is Lex in another court. Kindly allow a short passport.
Yeah, or yes.
May please, Your Lordship. My lord, we have filed this petition, my lord, for quashing of the criminal proceeding, my lord, against the petitioner. We have, my lord, the FIR, my lord, page 14. FIR filed by police, my lord, on the basis of information and allegation that, my lord, a truck was coming from, my lord, Kolkata, my lord, to Gauhati, carrying, my lord, cows, my lord. And public apprehended the truck and police arrested, my lord, the handyman and driver. On the basis of their statement, my lord, 5 persons named in the FIR, my lord, page 16. The petitioner is not named in the FIR. That case was investigated and charge sheet submitted, my lord, page 22. In the charge sheet also, my lord, there is no any allegation, my lord, or any materials against the petitioner, but his name has been included as accused. And charge, my lord, against him.
Absconder, my lord, in the search sheet.
Under? What again? Petitioner. আগে arrest করেছি তো।
So, oh, no, he is not.
He is
No,
not
no,
absconder.
he is not. Ziarul Haq.
Your petitioner is Amiruddin.
Muzammil, my lord.
কোনগুলো আছে? Oh,
Muzammil Haq.
Muzammil আছে।
Page 24, my lord. Section 379, my lord, as well as, my lord, section 11 of Prevention of Cruelty of Animals Act. 379, my lord, the petitioner, my lord, 379 will be applicable in this case against petitioner. He's not named in the FIR. He's no way connected. And illegal transport was carrying by two persons. They were arrested, my lord. And after receiving charge sheet, my lord, page 37, my lord. Some accused appeared. They applied for bail. Without taking cognizance, my lord, someone has been issued, my lord, in the last sentence, page 38.
Without, what do you say, without?
Page 38, my lord. Last sentence. Case fixed for appearance.
So form 38, what do you want to show?
On 38, my lord, the cognizance has not been taken in this case, my lord. Without applying mind, my lord, just, my lord, someone has been issued to the all accused, including petitioner. From the order itself, my lord, it shows that, my lord, application of mind is not there, my lord, while issuing.
Get an application, mine will come later on.
Lost.
Now, what is your case?
My case, my lord, against the petitioner, my lord, there is no, my lord, in the FIR, his name is not there. And in the charge sheet, my lord, there is no rule. Section 379, my lord, has been added against him, my lord. So against this petition, my lord, 379 will be applicable, my lord. So I have, and someone has been issued without, my lord, taking cognizance. So continuation of process, my lord, against this petitioner, my lord, will be an abuse of process, my lord. So I have approached this all court. Yes.
What prohibitions?
Yes, there are from the search sheet, there are pending, although in the FIR his name is not there, but during investigation, my lord, in the search sheet, pending materials against the, otherwise prima facie, my lord, those offences are attracted from the FIR, my lord. At this stage, charge not yet framed, my lord.
If, my lord, offense, my lord,
let him file a discharge application before the trial court. If, my lord, there is no materials, then, my lord, definitely trial court will discharge the petitioner. But at this stage, without getting the record, while pending material, there are materials, my lord, charge sheet, my lord, has been submitted. So at this stage, this is not a case for granting stay.
Lord, record may be called for, my lord, in the meantime, my lord, against this petitioner, my lord. Further
Charge is
proceeding.
not yet framed, right?
No, no, just someone has been issued, my lord.
That's what
Lost.
Mr. Botakuri is
Lost.
saying, that you can.
Regarding
pray for
other
discharge.
accused, my lord, they are involved because they are named in the FIR. They
You
carry
pray for discharge.
lost. That is, my lord, altogether different, my lord. If, my lord, there is nothing against the petitioner while he faced that
But here from
criminal
the charge sheet,
proceeding,
my
my
lord,
lord.
it reflects that pending materials against the accused charge sheet has been submitted. My lord.
Mr. R. Report. Yes. Charge sheet dated 9. The charge sheet number
And my lord,
01
395 IPC is also there. my lord.
395
09
category against the
2022 against the present petition under section 379 IPC related section 11(1) small a small b small d small e of Prevention of Cruelty to Animal Act, and also the impugned order dated 12/01/2022 2020, passed by Learned STTMS for PRC case number 11. Where they issue this to the respondents to speed post and usual post. Formal notice is required to be served on state
I told it.
call for the scan copy of the TCR along with its text. Further considering this submission made by Ms. Paul. Let the further proceeding in respect of the present petition be state till state court. Okay. Against you, there will be stay.
Deeply obliged. May I please, Your Honor?
Yes.
Well, this criminal petition section 158, Your Lordship.
Huh? What?
Your Lordship, on 4 occasions, Your Lordship, NBW has been issued against me, Your Lordship.
NBWA is issued. Where is the order sheet?
It's at page 14, Your Lordship. 5 copy is at page 12. 7/10/25. Your Lordship, this case is in final stage, Your Lordship.
Oh, it was in final stage. Why you could need absent?
Your Lordship,
For your evidence, it was fixed.
it was
For
fixed
DW.
Yes, Your Lordship.
Huh?
Your Lordship, the last stage was examination of defense witness, Your Lordship. And now it is for appearance since I'm not attending the trial, Your Lordship. Your Lordship, I may be given a chance, Your Lordship, to face the trial, Your Lordship.
Okay, but why you, I mean, did not appear, it was case was at the very last stage of the case.
Your Lordship, because of medical emergency, Your Lordship, I have annexed.
Just
two
tell us,
medical certificates.
prior to 7/10, what are the orders? Because 7/10 is the first date when your NBW was issued against you.
Yes,
Prior
Your
to
Lordship.
that, what is there?
Your Lordship, prior to that, on 29/7/25, Your Lordship, I was absent, Your Lordship, but with steps, Your Lordship.
No, where is the order? We have to come to know. Have we annexed the order? Before passing any order, we have to see your conduct. Na? Whether you were present in the earlier date, what was the last stage of the case, is not clear, na?
Your Lordship, I was last present at on 11/12/24, Your Lordship.
Where is the order? Now, see, you're saying that the case was at the very last stage of the evidence. Yes, I can understand. And on 3-4 occasion, the NBW was issued as you did not appear. Now, but we have to see since when you you are absent and what was the stage of the case.
Yes, Your Lordship.
No, you filed through an additional affidavit all this.
Your Lordship, I have the certified copies, Your Lordship.
Filed it through additional affidavit. You have not annexed anything here. Just an incomplete petition will not do, na? You are Mr.
Yeah, Rahman, Your Lordship.
Mr. A. Rahman. What break? Mr. A. Rahman, the learned the petition. Also had Mr. P. Bot, the learned petition. While hearing the petition, it has come to the notice that the relevant orders are not being published with the petition. In view of this, the petitioner is hereby directed to furnish all the relevant orders on the through an additional affidavit. Full stop. Let the matter. How many weeks you need?
Your Lordship, 1 week, Your Lordship.
You fixed date you need?
Yes, Your Lordship.
In that case, not 1 week. In that case, it will be when the next date is fixed. Can you tell?
17/3, Your Lordship.
17/3.
Yes, Your
Okay, then prior to that, 13/3.
Yes, Your Lordship.
By 13/3, you file all the order sheets because we have to see his conduct.
Yes, Your Lordship.
You are saying it is the last days, but there is nothing in the record from where we will get to know that it was in the last stage. Definitely, we have also a case that if it is in the last stage of big case, then it has to be disposed of. So there may be some order, but there is nothing in your record. So through an additional affidavit, you file all the orders prior to 710.
Yes, Your Lordship.
May not be all the orders, at least 4 or 5 orders, that so that we can come to know
Yes, Your Lordship.
through an additional affidavit based on 30.
In this case, madam, initially an FIR filed in 2009, saying
Initial
that this,
FIR.
2009, that the present petitioner, alleging that they are giving the false, fake doctors. Fake doctors, madam. Trial started. In the trial, they got acquitted, saying that they have never issued any prescription to anybody about the allopathic medicine, madam. They are patent, another alternative medicine, madam. This is a finding of the court. Again, my dude, after about 10 to 12 years, again on 25, second FIR was lodged on 29/9/25, was registered on 6/1/26, my. Same facts, my lord, saying that there is no new cause of action, only saying that they are the fake doctors. And they are saying, my lord, your lordship, kindly see, I have just take your lordship to judgment, my lord, acquittal, core issue, my lord. Page 27, my lord. Who says judgment?
Oh.
Now kindly come to my lord. Page 28, my lord. Point for determination, my just your lordship got it. Whether all the accused person, my total 4 person faced that my trial, my. Whether all the accused persons cheated the peoples of Dhubri locality as well as government of Assam by cheating or preparing fake document for illegally practicing as allopathic and Ayurvedic doctors, and further inducing people in government of Assam to believe that they are the doctors, knowing that they are fake doctors and thereby committed an offense under so and so, so and so. Now kindly come to my lord, page 30. Page 30, paragraph 14. Your lordship. The entire case of the prosecution as per the Azhar rests on an inquiry conducted by the informant along with Dr. Nurul Amin, Dr. So-and-so, so-and-so, and Dr. So-and-so, and that inquiry report exhibited in this case as Exhibit T. The Azhar divulged that the informant, Dr. So-and-so, the then Joint Director of Health Service, pleaded that after a joint inquiry, all the FIR named accused persons were found indulging in illegal practicing, and they are the fake doctors. This is the case as per FIR. Now your lordship can come to page, next page, paragraph 16, my lord. 16, next page.
16?
Page
16.
Paragraph 16. Now the question is whether all the accused persons were actually indulged with the allopathic medical practice. To prove the said fact, the prosecution side failed to exhibit any document before this court. 3 numbers of medical practice prescriptions were seized and exhibited. On perusal of the prescriptions, it is seen that nowhere in the prescription any signature of the accused persons were proved. They have not issued. Some rival doctors might have. There is no prescription where my signature of the accused were present. Even no expert opinion were obtained during the time of the investigation regarding the medicine prescribed in the prescriptions to prove the fact that those medicines are actually belong to allopathic or Ayurvedic. Then you will also kindly come to next page 32. Page 32, paragraph 19. I'm just giving you my relevant paragraph. Above all, to whom all the accused persons prescribed allopathic medicine or Ayurvedic during the time of their practice in different places of Dhubri district. To prove the said fact, the investigation officer also failed to examine any of those patients during the entire investigation. Nobody has come that they have issued a fake certificate or somebody might have suffered an injury or anything. The inquiry reports those are exhibited, Exhibit 3, 4 also failed to disclose any names of the patient to whom the doctors were actually prescribed the allopathic medicine. Paragraph 20, madam. Now coming to the cross-examination of PW1, it divulged before this court that the informant himself admitted that police has not asked him anything. Police has not recorded his statement. Accused persons are not personally known to him. He does not know where accused persons continue practice. There is no original public complaint found with the case. No complaint, nothing at all. Then coming to my conclusion, your lordship will find paragraph 37, my lord, page 38, 33. Paragraph, let us come to paragraph 37, my lord.
Para 37 or
37, page 39.
Paste.
13.
Yes.
36 and 37, my lord. Therefore, in the light of the above discussions, this court finds none of the witnesses are found to be truthful with the entire case of the prosecution. Rather, their evidence found to be full with a lots of shortcomings under which their evidence may be relied upon. Hence, this court finds evidence of the witness contradictory, untrustworthy in nature. The informant himself failed to clarify as to which of the medicine comes or falls within the purview of the alternative medicine. The investigation officer failed to collect any list of alternative medicine to tally the prescribed medicine of 3 prescriptions which were seized during the time of the investigation. The prosecution side failed to collect any list of alternative medicine to substantiate the entire allegations leveled against the accused persons regarding the fact that the accused persons were indulging themselves to be practicing the side of allopathic and so and so. So ultimately, my lord, that paragraph 42, page 40. Ultimately, they failed, my lord. Now, your lordship kindly, the same, there is no new ground and medicine, my lord, what actually what confirmed, my lord, this is the last page, page 66, Medical Council of India. Whole problem is that, my lord, our name is not registered in the Medical Council of India because it is not required. This is the certificate, page 66, my dear lordship kindly see, my lord. Huh? Type copy 65. Type copy 65, man. That Medical Council of India is writing, my lord, that with reference to your letter dated so and so on the subject above, this is to inform you that paramedical, allopatent, medicine, and so does not come under the purview of the Medical Council of India. As such, permission is not required to starting running paramedical allopathic medicine from the MCI as on date.
We are allopatent.
And we are allopatent, my lord. And now the FIR, second FIR, kindly see on page 52. On the face of that, whether it is, my lord, same thing they are saying, page 52. Yes. Now, Assam Council of Medical Registration, that is why we do not fall under that registration, my lord. In this, my lord, registration, some numbers were found where, my lord, it did not tally with the name of the petitioners. Your lordship got my point, my lord. Here the register, your lord, kindly see one paragraph, my lord. The registration number, third paragraph, my lord, in the FIR. The registration number so-and-so was allotted to Dr. Mushihuddin Ahmad on 1937. Register number so was allotted to one Gafur Sheikh. 20, register number so-and-so was allotted to so-and-so, who is more, whose beyond doubt that the registration numbers mentioned in the prescription letter used by Sri B.N. Singh has not been allotted to him by the Assam Council of Medical Registration or any statutory body. This is not required at all, my lord. The prescription, what I issue, madam, it is number, it falls under 59, page 59. Council of Patent Medicine, my lord. So they have confused, my lord, the Council of Medicine, Assam Council, or the Medical Council of India. We do not fall under this, as per your lordship has seen the last page of that here, my lord. So they have become confused and they have filed the present one only on that ground, my lord. So I think, my lord, already it is found and he is not at all practicing, my lord. There is no signature, nothing at all, nobody, no complaint is also there, my lord. Only at the instance of some rivals, my lord, that this was filed, got acquitted again after 10 years, my lord. This present second FIR was found. And notice was issued to him, na? No, notice not issued, madam.
He was arrested.
And you'll kindly see the matter, the very order. He was arrested, and on the same, kindly see the order of the arrest. Page
55, sir.
page 55. On the basis of the present FIR, he was arrested. Page 55. 57, kindly see my lord, that is order, bail order, my lord. On the same day, bail was granted on the ground that bail petition, kindly see my lord, also seen the bail petition number so-and-so by the so-and-so for the accused person stating therein that earlier, your lordship can note, earlier a similar case by GR case number that which your lordship has seen that acquitted was decided by this court against the accused person on similar ground on 30/11 to the 18th. That judgment was given. And in that case, the present accused, along with other accused persons, were acquitted from the case. Today, again, IO of the case has booked the accused person and registered the case under section so and so, so and so. Accused person innocent, so and so, 73 years old, my lord, this person. I have gone through the materials available in the case record, and after going through the same, it appears that except section 3162 BNS, all other sections are variable in nature, punishment of section so and so, so and so, so and so. So ultimately, on that basis, bail was granted. Because the materials available get come to notice of the court that although the accused person was served, that notice part might have taken. So on the face of it, whether a further proceeding is to continue or not, that your lordship to examine.
Yes, what?
My lord, although, my lord, I will point out, my lord, from the order of the bail order dated page 57, my lord, although it is stated that during submission of the petitioner, this is similar case on similar ground. But in fact, my lord, whether this is a similar case, my lord, your lordship, a petitioner, my lord, there are on the basis of some allegations that he is a fake doctor, my lord, at that point of in the year 2009, my lord, and thereafter, due to lack of evidence, my lord, in the year 2018, my lord, he got acquitted. Whether, my lord, the accused person who got acquittal in the year 2018, whether on the basis of that acquittal order, he can be allowed to continue that offense, my lord, continue to, my lord, on any type of offenses in QSR also, whether he can be protected for all QSR offenses, my lord, in view of that acquittal order, my lord. At that point of time, because he got acquittal because there was due to lack of evidences, my lord. And your lordship may, this is not a similar, your lordship may kindly come to the present affair, my lord. In fact, admittedly, my lord, during submission, my learned senior counsel has pointed out that he is not a allopathic doctor.
Yeah.
Admittedly, he is a doctor, my lord. Only for, my lord, alternative medicine, he cannot prescribe any allopathic medicine, my lord. And here at that point of time, my lord, because, my lord, while pointing out those paragraphs, my lord, that, my lord, the IO at that point of time failed to produce any prescriptions regarding, my lord, he has prescribed any allopathic medicine, and during investigation, my lord, during trial also the evidence could not, my lord, prove those allegations against the petitioner, and only because of lack of evidence at that point of time, petitioner got acquitted. And regarding the present affair, your lordship may kindly come, my lord, and admitted presently also admitted position is that he is not an allopathic doctor, my lord. And your lordship, I would like to point out, my lord, and during submission, my learned senior has also pointed out that, my lord, being a my lord, alternative, my lord, practitioner, my lord, he is not, my lord, required to register himself in the Assam Medical Council or Medical Council of India. But, my lord, he has in fact used some registration number, my lord. And that your lordship may kindly come, my lord. Third paragraph of the FIR, my lord. I would like to bring to your kind attention
FIR
that
was again,
one
just here, FIR was page the number.
page 52, my lord, the present FIR.
Second,
Present FIR, my
Yes,
lord.
yes. In which para?
Third paragraph, my lord, I would like to bring to your kind attention, my lord. Kind attention that one individual by the name of Dr. So-and-so, the present petitioner, is practicing as a medical practitioner and as a specialist in medicine at a clinic situated at Panchmore, Dhurinder, your jurisdiction. Suppose this is a similar allegation, my lord. This individual has mentioned that he is the holder of some unrecognized qualifications like MD, EMS, MD, patent medicine, FWT, etc., and displays registration numbers. So he displays registration numbers and claim to be a senior physician and claim himself to be a senior physician. Evidence one. This individual was also practicing as a doctor at Gauripur. Evidence 2. My lord, those are not the, my lord, annex along with this present FIR. Only FIR is here, but those annex is not annex. The registration number 1142 was allotted to Dr. Mohisuddin Ahmed on Iman. Registration number 91 was allotted to Gofur Sheikh Abdul, since deceased, on 18 to 1920. And registration number 172 was allotted to Omulyodhar Rajkua on 5/4/24, which proves beyond doubt the registration number mentioned in the prescription letter has used by B.N. Singh. So he has used all these registration numbers in his prescription. But during the earlier case, those evidences are not there. By him, the ACMR or any statutory body, since evidence 3, 4, and 5. Your attention drawn to the circular. These are, my lord, I will not, and again, my lord, your lordship may relevant portion, your lordship may kindly come to page, my lord, 53, my lord. And other paragraphs also, my lord, there are evidence up to, my lord, evidence 7, my lord, page 53, your lordship may kindly come. That page 53, my lord, from the first line, my lord. The Director of Medical Education, Assam President, Assam Council of Medical Registration, has categorically stated, mentioned that Schedule A drugs can only be prescribed by none other than an allopathic doctor. Hide his letter number so and so, dated September 19, 2022, evidence 8. Those the copies of the prescriptions, these are the copies of the prescription issued by Dr. B.N., the present petitioner, to the patient, which has been attached as evidence 1 and 2, has Schedule A medicines prescribed to patients seen by him, and he has been treating patients suffering from notifiable diseases like dengue, my lord, which is not authorized and competent to do so. In addition to not informing the government of such patients being treated by him, which is a gross violation of the law laid down laws in force for ensuring public safety and containment of communicable diseases. So those evidences are not there earlier, my lord. So due to lack of evidence, he got acquittal, my lord. Whether that acquittal order, for that acquittal order, my lord, he can be protected for all future offences, my lord. Now from this, my lord, affair, it seems that there are evidence up to evidence, my lord, 1, 2, 3, 4, specifically mention about all those evidence regarding the prescriptions, my lord. In fact, although, my lord, he is not permitted to prescribe those medicines, he has, my lord, there are, my lord, evidence regarding prescriptions also, my lord. So, my lord, can he be allowed to continue these offences? My lord, these are serious offences, my lord, playing with the life of the people, my lord. Being a, my lord, alternative medicine doctor, he can prescribe only certain kind of medicine which are specifically, my lord, allotted to them. But here, my lord, he is treating patients like a allopathic doctor, my lord, by using those registration numbers, my lord. In fact, those registration numbers are not of some different person.
But only this is the case, madam. Your already adoption 3 prescription issued, the signature was not there. Now, my registration number, I also say, madam, this is not the registration of the medical council because I do not fall under them. It is my patient, that number I am using, madam. And whether anyone, any person, madam, has filed any complaint that he has issued allopathic medicine to me, not,
There are evidence.
nothing is
Those
there.
prescriptions are the evidence here now.
So earlier also prescription page 31, your lordship, the signature was not there.
No,
Now whether any prescription is there or not, my lord, in the FIR, I do not find.
No,
They simply say that he using the number and so number which belongs to some other person. That I also admit. That number does not belong to me.
And why are you using that?
I am using in by way of the page 59. My number is there, madam. I am using the number which is issued by my own.
But as per the FIR, you were using those number which was not even allotted to you. And that apart, your submission is that their registration may not required under the Assam
Medical Council.
Medical Council. Now the question is that in the earlier case, definitely there are some loopholes of the prosecution side for which you got acquitted because those could not be produced. If you go by the FIR in this case, I don't know what they have collected. If you go by the FIR, particularly the evidence 1, 2, 3 has already been prescribed, how and what manner you were using those registration numbers and using
One
those
to
medicines.
I understand. Your 1, 2, my lord, they says he is using this number. That is what's saying. 2, 1, evidence 2 is using this number, which belongs to some other persons who already might have died. That is my lord. But there is no allegation that says issued a prescription to such and such persons, my lord.
Now it will come because while conducting the inquiry, those
My lord,
were
that is
there.
Council of Patent, page 59.
Yes, now those will come as to how you are, I mean, though you are a doctor of alternative medicine, how you are prescribing the allopathic medicine that
Whether I have
in some
prescribed,
communicable diseases that
whether I
like dengue
prescribed
and
or
all.
not,
Pardon?
whether I prescribed or not.
Oh,
Allopathic medicine, I
as per the FI, you have already prescribed, treated with those the patients playing with their life and all. Because those are very communicable. Even dengue, there's a death rate.
No,
you know.
any person, whether I made any complaint or not, madam, I'm only on that.
Taking advantage of that equitable order.
Yes.
Yes, no, I am true, madam, because it is naturally, madam, we are equally concerned, madam. Everybody is having, madam, we go to the doctors, madam, equally concerned. Only question, madam, is whether there is any prescription he has issued, madam, to any person who has come to the
Now
police.
this will come because he is using those in the registration number in his prescriptions.
Yes,
In the earlier cases, those prescription with this signature could not be produced by the IO acquittedly.
right.
Those were the loopholes. He got acquitted. Undoubtedly, I don't have. And you have shown the page 59,
Yes.
wherein this says that such registration may not be required under the medical council's rules.
No,
That
page
is also
59, under that council, I use my number, madam.
Patent medicine.
Patent medicine.
patent medicine.
66 is
Now,
the
now, but the question is that with using those registration number which is not even provided to you, you were using those numbers in your prescriptions and providing medicine. And also, I don't know, some their particular medicines are there most probably which came under the H category. Those were also provided by you. These are the allegations.
that is the allegations, my lord.
Allegations.
But on the face of the 73 years persons, my lord, he naturally he is not a man of that here, my lord, that is issuing whether any case of negligence, any case, anything. That is, I am only on that, my lord. Anybody, any case, whether they have
What
suffered.
is the stage of the case at present? Can you tell
No,
us?
stage only, my lord, it is FIR was filed, no further progress, my lord.
It states
It was registered on 6/1/2026.
still under investigation.
Yes, they are involved.
Then we can call for a case diary.
Yes, yes.
What amount is
Otherwise,
it?
my lord,
Otherwise, you are on bail, I think, on the first day.
Yes, yes,
Otherwise, my lord, taking advantage of that
No, I am,
order, my lord, he
I am
cannot,
equally concerned.
yes,
It
involved
is
in
not that, my lord.
Yes, my lord.
Everybody is my lord. Yes.
So you are basically come here for washing of the FIR.
Yes, question of FIR. Second FIR.
Part Mr. H.I. Chaudhary, Dilanit Senior Advocate, assisted by
SS Ahmed.
S.S. Ahmed, Dilanit Counsel for the petition.
because
Also by Mr. P. Bott, Dilanit Edition, appearing on behalf of state respondents in application
Are you prohibited?
India for washing of the FIR that is 06/01/2026, registered under the previous case number 07/2026, corresponding to GR case number 27/2026, under section 3192, 3162, 3362, 125, and 271 PNS. Issue notice to the respondents through speed post and usual process. No formal notice is required to be served. State response number 1, and also call for the case diary. It is submitted by Mr. Charlie Chaudhary, Dilanit Senior Advocate, that with the same allegation, earlier case was lost in 2009, wherein the present petitioner got acquitted as the prosecution could not even prove prescriptions, any prescription issued by the present petitioner. But after say about 10 years later, this petition, the FIR is again lost with same set of allegations, wherein it has already been discussed and decided by in the earlier case. Further, it is submitted by Mr. Chaudhary that as per the Medical Council of India, the permission is not required for starting, public running, paramedical, allopatment medicine, ALL, allopat, ALLOPATENT, allopatment medicine, and CMS and ED courses from MCI as on date. Accordingly, he submitted that this is a quick case wherein the order of washing can be passed and the further and the inquiry and further investigation may be stayed at this stage. Mr. Gauhati raised payment objection and submitted that it cannot be a case that it cannot be permitted to practice with such kind of practice cannot be permitted to practice as a doctor in allopathic medicine without having even any risk, without having any degree. And from the scene that in the earlier case, there are some prosecutional loopholes wherein some medical evidence as well as the documentary evidence could not be produced by the prosecution. But here in the instant case, from the FI itself, it is seen that many evidences have already been collected by the IO at the time of filing the FIR and by the informant at the time of filing the FIR, and the evidences are also described systematically in the in view of this, he submitted that at this stage CD may be called to know the entire fact of the case. Accordingly, that his diary be called from the concern or from IU. List accordingly when it can be listed.
On 25th of March, 25th.
We'll do 25th of March.
Almost similar nature of the case, my lord, but not Dr. my lord. He is an associate professor of that earthquake seismology, my lord, department of that in NIT Silchar. He joined in 1997, my lord, and FIR was filed page 47, first FIR, my lord. It ended in FR. Then again, one second FIR was filed, lodged, my lord.
First FIR was ended in FR.
FR. Now kindly come to the first FIR, my lord, page 47, first FIR, page 47.
That FR
FR is page
FR
40.
is accepted already.
No. FR, the court has issued notice to him.
Ah.
Then thereafter ask him to file a formal complaint if he were agreed. But
Now this
that
case.
informant. He 20 adjournment he sought for 25 to 3 years had gone. After 20 adjournment, he come and file a fresh complaint. And the court has taken cognizance of that, issued notice to him. This is that. Now kindly come to my lord, page 47 is the FIR, my lord. First account full page 20. Page 20. Huh? Just my page 20 first, my kind. I'm sorry, my lord. Actually, he is an expert in earthquake, etc. For that, the government has issued some scheme. And he was kindly see page, annexure 2, page 19, my lord. No, page, sorry, madam, page 18. Ministry of Earthquakes, my science is taking initiative about the earthquake hazard mitigation, its awareness and season, and seismic hazard so and so in the Indian standard so and so. Then your lordship can say after the submissions, ministry will review. Dr. T. Rahman, present petitioner, my lord, last but 4 lines of the paragraph 1, my lord. Dr. T. Rahman is requested, the present petitioner, to make a proposal for the earthquake hazard mitigation project for the financial year 14-15 to the Ministry of Earthquake so and so so and so. This is a project. Then preparation, it is mandatory to open a separate account for the proposal. 2, subclause 2, your lordship will find. Or for the each project, there will be a 3 my lord, members committee comprising of 2 from the Ministry of Earthquake and others from Ministry of Earth Science will monitor the so and so. Then your lordship will find next paragraph, my lord. That respects, I have written to the authority. I have written to the authority. I have received officially the checkbook of the saving account number so and so in the Axis Bank Silchar, so and so as your directive. Also, I have come to know for the first time about the opening of the said account by NIT Silchar in the Axis Bank. After receiving the checkbook, I have also come to know from you and account section of NIT Silchar that you have empowered me to operate the said account individually. Also, I have been informed that all these records such as opening of account, receiving of checkbooks, and authorization to operate the said account available in the account section. This account was opened by you at the institute level for submission of the project proposal to the ministry. Then there will be a lot of consultancy works. This is the my dear kindly my dear. There are a lot of consultancy works with respect to this project in seismic activities and related designing, testing of buildings, so and so. I may be permitted, kindly note my dear, I may be permitted to carry out all these consultancy works in addition to the said project and also allow me to operate the savings account number so and so in the bank in the name of NIT Silchar with these consultancy works so and so. So what he says, my dear, he himself is an expert in the subject, so he also offered the consultancy service. For that, he gets some amount. So he wanted that amount also to be deposited in this account, my. This is what he meant to say by this word. And this was approved by the director, my. Signature is also there, my. Then your lordship will find welcome, annexure 3, my lord, page 22.0. After opening the account, dear NIT Silchar, they are writing. It is, my lord, normally after opening account, they are given a welcome letter, my lord. So this welcome letter is in the name of the director of NIT, my lord. In the name of the institution, not in my name. Your lordship got my point, my lord.
Director of NIT.
The NIT. So welcome address, you have open account, we welcome it, that you have Axis Bank, my lord. Then proposal, you are kindly page 21. From director to Bansa Ministry of So and so subject proposal. Respected sir, with reference to subject, I am forwarding a project proposal titled Seismic and Seismic Hazard Study of the Northeastern Region of India from page 1 to 19, which is submitted by the present petitioner. Associate Professor, Department of Civil Engineering for February of kind consideration and sir reaction, please. Then project etc. I am not taking the receipt. Then kindly come to page 47, my FIR. Well, one thing I make clear that in the project, no money has come from the government of India. That the project, but no money has come from the government of India in the project. Only consultancy service what I got, that is deposited in that year. No money come from government of India. It is a categorized state, my lord. And in consultancy service, my lord, NIT also got some share. I do it, but some share is to be given to NIT. That also I paid. Page 40? 43. Now come to page 47, my lord. I have the honor to inform you that the below noted accused person who happens to be an associate professor, Department of Civil Engineering, Shillong so and so, Shillong Patti Silchar branch, can open a saving account. I have not opened. That itself is a wrong, my lord. Engineering NIT Silchar illegally opened a saving bank account number so and so and has been operating the said account since January 14 in his personal capacity and in the process of siphoning of the government fund by channelizing the same through the said bank account. The institute never authorized the accused person to open any such account. I have never, your lordship has seen, the account is opened by the department, asked me to operate that here, my lord. They have asked me to that here. And that after his fact came to light for the first time on receipt of the statement for the said account so and so, Silchar, the informant called upon the bank authority to furnish a copy of the statement of account of the said account so and so, my lord. Let us skip, my lord. Then that the person has been withdrawing money from the account deposited by the different government and other agencies for his personal use without any information, so and so. So this is the case. Now kindly come to my FR, page 49. Very clearly they have written everything, my lord. Let us come to my lord, page 50, during investigation, my lord. During investigation, the alleged bank account and the official records in this regard was verified. And it was found that the alleged bank account in the Axis Bank was opened in the name of Mrs. NIT Silchar. Your Lordship got the point. So it nullifies the very, my lord, that I have not opened the account. Officially, not in the name of the alleged accused person since January 24 for the purpose of a government project for the institute. But, Your Lordship, but no government project as well as no government fund was sanctioned in that account, which was utilized by the faculty for the consultancy works from various private and government agencies for the benefit of the institute after proper endorsement and authorized by the authorities of NIT. The authority is well concerned with the suspected account because just after opening the bank account, the bank authority sent a welcome letter to the authority NIT Silchar, and checkbook of the account was sent to the authority of NIT was duly handed over to the alleged person, and the bank account statement of the said account was from time to time received by the authority. During investigation, there found a gap between register branch and account branch. This is the reason why, madam, some misunderstanding might have taken place, madam. Communication gap between the register branch and the account branch of the NIT, for which the suspected account was not maintained properly without any audit up to the closing of the said account. Finally, the said bank account was audited by the alleged person by a authorized chartered accountant, and the share money, including the tax, Your Lordship, was deposited to the SBI bank account of NIT Silchar through account number by the check number so and so, so and so, so and so, so and so, total amount 13,76,000, which was duly received by the authority of NIT. I have deposited that amount, my lord. During investigation, they have found no any government fund misappropriated by the alleged person for which the Honorable Court of Litigation Session just granted him anticipated bail. Even the complainant himself does not know how much money was misappropriated by the alleged accused. Above all, in this regard, the alleged person was suspended from the job, and after departmental inquiry, he was appreciated for his job for the NIT Silchar, and his suspension was revoked. During the course of investigation, it is seen that the evidence is insufficient of the alleged offense under section so and so against so and so. I therefore suggestion so and so. So, Your Lordship, seen first question, I have not opened the account. No government money has come. Whatever money deposited, I earned from the consultancy service. I have also deposited to the share of the NIT in the bank also. That is also, it is clear, my. Now, Your Lordship, in the second FIR was lodged, my lord. Oh, so notice, Your Lord, kindly see that notice, page, protest petition, my lord. Notice is page, informant appeared. 57. Page 57. In that case, my lord. So FIR is 17. And FR is 19. FR is dated 31st July 2019. July 19. And 24/2/20, Your Lordship will find page 57. Case record is received and transferred. After how many years, my dear, Your Lordship will sign? Case record is transferred for disposal. Case record is put up today. Peruse the case record. IO has submitted final report in this case. Issue notice to the informant. So and so notice issued, and Your Lordship can see the date. How many dates, Your Lordship? 20 dates from page 57 to 63, 64, 65, page 64. Your Lordship will find up to 3. up to page 73, including COVID period, my lord. After COVID also, my lord, COVID-19 from 20, it started, notice that they have taken 20 times adjournment. Then he filed the petition, then kindly see page 73. And exact 10. Informant Jahiruddin Barbuya is present today and filed objection petition. Seen the objection filed by the informant stating that he has objection against the FR submitted by the IO and willing to proceed with the case. Peruse the case record, case diary as well as the objection filed by the info. Considering the materials available in the case diary and considering the contents of the objection, FIR submitted by IO is not accepted. Let the complaint case is registered on the basis of the objection. Then your lordship will find his objection is page 74. Petition. Long I am not reading, my lord, but on the face of the FIR, my lord, whether my lord, further that it is to proceed or not, that your lordship is there.
Here, yes, only I have gone through the final report, my lord. Here, informant is the register of the NIT Silchar,
Yes.
and the present accused person is the associate officer of the NIT Silchar. And from the final report, prima facie, it reflects that initially one Axis Bank account was opened, although in the name of NIT Silchar, but the present accused petitioner has withdrawn money from that account in his individual capacity, my lord. And thereafter, ultimately, my lord, those amounts, my lord, which were those balance account or ultimately, my lord, he is forced to transfer an amount of rupees 30,86,057 to a particular SBI account.
Yes,
Initially from the Axis
Correct.
Bank account, although my lord in the name of NIT Silchar, and ultimately those amounts were ultimately transferred to a SBI account, my lord.
So NIT
Although the earlier account was although in the name of NIT Silchar, but my lord, the present accused petitioner operated that account and he withdrew some money from that account, my lord.
Operated
Now,
in a sense, there is an most probably approval was there when he paid for to make the to operate the account. There was a petition. Most probably
in the
prayer was
final
made.
report itself, my lord,
No,
allegation is that
he has pointed out, Mr. Chaudhary has pointed out one thing was at what page? Just forgot. Maybe
Yes, Prashant, you have this is it, madam.
one letter was wrote to wrote by him. In fact,
It is a fit case, my lord.
police has already submitted final report, my lord. Informant is there, so your lord may issue notice to the informant, my lord.
In the
And
meantime, my
records
lord,
of the, my lord,
it
that
is
case may be called for.
because he wrote a letter, I think, operated account
Huh?
that was approved.
yes.
19.
Page 19, page 19. Account was approved, my lord. That's page 19. I have informed.
So he took the initiative that though the NIT Silchar, but he may be permitted to operate
Yes.
this thing, and that was approved most probably allowed.
Yes.
Axis
So
Bank.
thereafter, these things were there.
Yes. So otherwise, my lord, those
Yeah.
my lord, the
And
documents
I have
need to be
received enough money for consultancy. I have given tax to the SBI account of the
This
NIT.
is there.
Yeah.
Wait.
I leave your lordship. It is a fit case for your lordship.
At this stage, your lordship may issue notice to the informant, my lord, and
Card,
can
Mr.
Doctor, thank you.
HR assisted by whom? You assisting?
AHMR Chaudhary.
AHMR Chaudhary. Please tell your full name.
Abul Hakom Muhammad Rajwan. Abul Hakom Muhammad Rajwan Chaudhary.
Abul Hakom Muhammad Rizauddin.
Rajwan Chaudhary.
In India, my lord, it is the longest. I thought my name is longer, my lord. Now I find his name.
There was one film called the name, wherein his paid name, he was a South Indian person. His paid name was very big. It's a simple comedy name. But he is not so, his name is not so long. So and so.
Abul Hekmat ki.
This is an application. Also, hard district report. An additional PP opinion on the it's an application. PNSS. And it will against the order dated 30/4/2025 CGM Silchar in GR case number 613 of the 2007, corresponding to Silchar PS case number 351 2017 1 409 IPC, whereby the FR submitted by the police was not accepted and issued notice to the so if you notice to the respondents to register it must to be post New Year process. Formal notice is required to be sent. Also call for stamp of notice. Further considering the submission made by council for also considering the fact that during investigation of police filed the FRX and granted the further proceeding in CR case number 142 of the 2025, pending in the court of Senate GMFC Kachar City. State. How many accused persons are only one?
One.
We state till next estimate as a okay, it will be state for next year.
Obliged to. Only CR case number.
Yes, I have mentioned it.
Obliged to us.
May I please, Your Lordship?
Yes.
Lordship, in this case, petitioner had earlier on approached before this honorable court to filing another criminal petition and for quashing of the NBW. So that was allowed by this honorable court on 19/1/2026. I kind of find that order at page 34.
Yes, the order is there.
Yes. So here, NBW issued on 6/11/2025 was set aside and quashed, and this honorable court was pleased to direct the petitioner to appear before the learned trial court within 15 days and file appropriate petition, and that would be considered as per law. So, complying with this High Court direction, he had appeared before the learned trial court on 22nd of January and file a bail petition that he may be enlarged on regular bail. So that is rejected by the trial court, saying that Honorable High Court has given this liberty to me to decide the petition as per. So therefore,
now he is in custody.
Yes, custody warrant was issued. But in the meantime, fortunately or unfortunately, he loitering in the court premises up to 4 p.m. And due to his family medical emergency, he left the court at 4 p.m. So unfortunately or fortunately, he was not taken into custody because he could not inform his counsel also because he had called several times, but might have been that he was in court proceeding busy, so he could not get contact with his counsel, and he left the court premises. And thereafter, in the evening, his counsel has had informed that custody warrant has been issued and bail petition was rejected. So on that fact and basis, this present criminal petition against the custody warrant. So
where is the order of issuance of custody?
Yes, my lord, page 36. Can you find? May I read one? Accused Amiruddin is present and white petitioner so prayed for allowing him to go on bail. He has also prepared through a copy of the order dated so passed by the Honorable Gauhati High Court. Heard both the sides. It is pertinent to mention in the order dated 19/1/2026, the Honorable Gauhati High Court had directed this court to decide the regular bail prayer in accordance with law. Hence, this court is at the liberty to decide the bail petition on its merits
considering the fact that section 395 IPC and section 397 are very serious offenses, and the fact that the instant case will be on the verge of committal to higher court, enlarging the accused person on bail will affect the expediency of the case. Hence, I am not inclined to allow the prayer made on behalf of the accused person, and accordingly it is rejected. Bail petitioning disposed of. Accordingly, issue custody warrant. So, the learned trial court on two grounds, that seriousness of the section imposed in this case, and this case is on the verge of committal. So at this stage, if I incline to enlarge this petitioner accused on bail, it would hamper this case. So my humble submission I have given in my pleadings grounds so that this would not be a cogent reason to reject my bail here. And another fact is that I have stated in my petition that I am not the FIR named accused person, nor my name has been mentioned as a charge sheeted accused person. My name is yes, no, it is at column 11, that is non-charge sheeted person. Kindly
You are
find,
non-charge-sheeted person.
yes, kindly
What is
find at
Absconder,
You are absconder charge-sheeted,
Absconder,
non-charge-sheeted. If you're not charge-sheeted, then
Absconder.
no case is against you in that case. Now, what is your prayer?
my
Stay
lord,
suspended.
at page
well, on that day, in fact, he was present in the court. But
Yes,
while
sir.
after rejecting the court,
He fled away.
he was kept away from the court premises.
no, not fled away, but I have stated here.
For medical
After-
emergency.
Yes, after 4 p.m. he was loitering in the court
Actually,
premises.
direction has to be made.
See, and
But-
generally also in cases like 395, 397, it is very, it is not easy to identify the persons of these dacoit and all. So definitely name may not be there.
My lord,
This is the inquiry when your name has become.
another fact is that
Hmm.
this Honorable High Court was pleased to set aside that NBW on the basis that his name was not in the FIR and he was totally unaware about this
Nice.
pendency of this PS case as well as stuff.
That's considered by the court.
Yes.
Let him surrender before the trial.
I am ready to surrender, but my only prayer would be that I may be given a protection, and it is
protection.
my lord, a protection that is in a sense that I should not be taken into custody.
Oh,
My lord.
acha, acha. Heard Mr. S.C.
My lord.
also for the petition. Also for Mr. Report and a petition. Then application. In section 828. Oh. Genesis seeking quashing and recalling of the custody warrant dated 22/01/2026 issued by the petitioner, issued against the petitioner by the learned GMFC Nonga in PRC case number 1582/2020. And also for the setting aside and quashing the order dated 19/01. Past no, sorry. Mr. Dalsey, learned counsel for the petition submitted in this week that earlier the present petitioner preferred and failed a criminal petition before this court seeking interim protection and also with a prayer for suspension of his warrant of arrest. And it's order dated 19/01/2026 in criminal petition number 1528 of 2020. The petitioner was asked to appear before the learned trial court below within 15 days from the date of order with an appropriate application for bail, suspending, staying the NBWA issued against him. If I had submitted that in person to that order on 22/01/2026, the petitioner appeared before the learned trial court below with a bail application, but that said petition was rejected basically on two grounds. One, for seriousness of the offense, and another ground is that the bail of the present petitioner at this stage may hamper the process of committing case for decisions. He was there in the court premises up to 4 p.m. But thereafter he had to rush immediately to due to some medical emergency with his family member. And thus he was not in custody too. The custody warrant was issued against him. He further submitted that it is only for the medical emergency he could not physically present before the court at the time of issuance of custody. However, he is still ready and willing to contest the case by appearing before the learned trial court if some interim protection is. Next one, Mr. Bott, the learned petition submitted that from submission made by learned counsel for the court itself seen that after the earlier rejection order of bail on 22/1/2026, he fled away from the court premises, and for which the custody warrant could not be executed or he could not be taken into custody. He accordingly submitted that no interim protection could be provided to the present petition. However, he may surrender before the learned trial court with an appropriate application. Considering the submission made by an Sinda, even after considering his earlier prayer, even after considering his earlier prayer, this court in the criminal petition number 152A had suspended public stay the NBWA issued against him with a direction to appear before the learned trial court below within 15 days. But it seems that even after the said order, even after the said order and rejection of bail petition, he could not be taken into custody as he was not available at the relevant point of time. In view of this, considering the other aspects of this court is of opinion that no interim protection can be provided to the petitioner. However, he is directed to surrender before the learned trial court will immediately with an appropriate application, which may be considered with the present stance. No interim protection is provided to you. However, you are liberty to.
Yes, I'm ready to
before
surrender.
the learned trial.
But my lord, if since my name is not in the FIR, so
No, see, that's what I'm saying. Your name cannot be in the FIR. You are a dacoit. How a name of a dacoit can be there in the FIR?
and he was totally unaware of this penalty.
After committing dacoity, you will be present there. How the house owner or
we are asking for visiting right of the minor child minor. So my learned friend very fairly submitted that he has also no objection to the visiting right. So in that case, my lord, page number 18, that order is there.
Appropriate. Lordship, matter might be listed in the appropriate bench. It is a civil bench matter. So your lordship is taking up the
civil bench.
Yes, civil matter.
But I don't know, most probably, was it a part-heard matter? No.
No, it's not part paper.
Why it is listed?
Your lordship was pleased to issue the notice, and in the meantime, that lower court proceeding was stayed, and they have come for the for modifying that order.
Okay.
So if it may be listed in the civil bench,
It should be listed
bench,
before,
appropriate bench will decide.
Do you want any fixed date there?
On 6th,
Star has told
on
6th of March.
6th of March.
We don't. And he requested by the council. Let the matter be listed in a appropriate bench on 6th of March. Raised you. Okay, we're listing it on 6th of March.
Civil bench.
Obliged.
March of next.
before the appropriate civil bench. Twenty? 20. Which need? Yes, yes.
My lord, here we have received the case diary, my lord.
Updated case diary you have received.
My lord.
Was there any interim? No.
No.
They are absent. How many since their date of arrest is?
My lord, their date of arrest, my lord, 31/1, my lord. 30.
30.
My lord.
Well, month of February is
My lord.
almost gone, almost 1 month.
Almost 1 month, 28 days.
They are absent now. So what to do? CDB detained?
My lord.
Because they are in custody.
My lord, custody, my lord, yeah. Next Monday or Tuesday.
None appears on call for the petitioner, both 23 to 24. However, it is submitted that Mr. Sharma, the unit additional BP that CD has already received. In view of this, let both the matters be listed. Monday, there are many matters.
Tuesday, my lord.
Tuesday, Wednesday was closed. Thursday also 6th. 9th of March.
My lord.
List on 9th of March. CDB detained.
My lord.
26.
Proceed. Senior as what will appear in this case 26 and 26. Only pass.
26
and 27. Hmm? 28, 29 also. CD receive, my lord.
But 28, 29 is out of same.
Same, my lord, out of same, my lord. Two accused persons are here, my lord.
And whether they are on injury?
No, my lord, they are not interim, my lord. Here, what happened, my lord? Both of the accused person has assaulted one person, my lord. And not died, my lord, but somehow he survived, my lord. But he, as per my lord statement and others, his memory was lost, my lord. Memory
Now
loss.
he cannot say who
My lord,
assaulted.
my lord, that statement are here, my lord. But identified by the father, my lord. At night when they are returning home from functioning, there is some function, my lord. Then both of the accused person assaulted, my lord, brutally in the head, my lord. In the medical report also received there is a head injury, my lord. Grievous. And thereafter, my lord, after some days he was examined, my lord, but he has forgotten, my lord. Who assaulted by what happened, my lord. That is here. And one important thing also here, my lordship, if lordship wants Paris, my lord, as they are involved in this matter. I continue.
It's not there.
And the present petitioners are Rubindra and Vibhuti, both of them. After the incident,
The witness.
Yeah, one of the witness.
But popular the Vibhuti
After the incident, my lord, they were along with the
not seen the incident. Anyway, they are
my
absent. Right? So retaining of case diary.
AB, my lord.
AB only.
My lord.
Where they will be returned or what to do?
If it is in the, my lord, next week, my lord, already medical report also received, my lord.
Can be fixed on next week.
My lord. If the next week fixed, my lord, then schedule it in, my
10th of March.
my lord. My lord.
Both 20 is 20.
28 and
28.
29.
28 and 29 also.
Also, my lord.
Out of same.
Out of same.
So one is for Vibhuti and one is for
Ravindra, my lord. Ravindra and Vibhuti.
Robitra and appears on call for repetitions. However, it's submitted by Mr. V. Sharma, the land representative at CD, along with the medical report has already been received. That he is here. Yes, Mr. Kalita, please come.
Fine.
I'm just
Sorry, Lord.
giving dictation.
Sorry, Lord. See, Junior sir, they are sitting in different court.
Oh, how many matters is fixed today for you in your different benches?
In High Court, Lord, there are 8 matters.
8 matters.
And Lord Court also.
After some time, my lord, this is
Take some rest then.
Then, Lord.
Okay, just I'm just
CD
getting your case diary is also there.
Yes.
Case diary, we'll talk about details. Okay, take some rest. What is about 30?
My lord, here one report was called for, my lord. Regarding whether any case is pending, my lord.
Potashil Ambari.
My lord. We have
Okay,
received
what
the
is
report.
report
my lord.
says?
Case ready.
No case is registered.
No case. So till date, no case is registered against.
Yes.
So as and when if any case is registered, then you can definitely approach before this court.
But Lordship, petitioner received phone call from Ambari's
So,
house.
see, on that basis only we have called for the report.
Right.
Therefore, we cannot give a blanket protection, and that is not possible. So if it is supposed register the case,
Yes.
then definitely you will be at liberty to approach this court, and that case will call for it. But till that, there is no case. So on what basis will take against it? That's your MSA Begum?
No, P. Odhikari on behalf of
Oh,
A.
sorry, P. Odhikari. Hard MSP Odhikari appearing on MSA Begum. Also hard Mr. P. Sharma and additional PP appearing on behalf of citizens. It is submitted by Mr. Sharma. The report has already been received from Patasil Ambari PS. Wherein it is stated that as per the official record, till then no case has been registered against the petitioner, namely Pintu Viswas in Fatashil Ambari case. Your petitioner's name is Pintu Das, no?
My lord, Pintu Viswas, my lord.
Viswas.
Pintu Viswas. In view of this, the present accessibility and its the present bill application is thereby disposed of. However, the petitioner is at liberty to approach this court in the event any case is registered against him. With the above observation, the present petition stand disposed of. The report be kept with the case.
My
Lordship. Lordship, I am for 23, Lordship.
It is already gone.
Lordship, because of the fasting, Lordship, I went to washroom, Lordship.
What to do? 23 and 23 is already gone.
Lordship, please, Lordship. Lordship.
Sorry, we have fixed a date otherwise. Both 23 and 24 are there, na?
Yes, please. Lordship, almost,
it on 93.
always, almost 28 days, Lordship.
93 we have already fixed. What to do?
Almost 28 days, Lordship.
I can understand, but 93 we have already fixed. Oh, yes, madam.
28 and 29.
Okay.
Yes, Mr.
Lodge.
Kalita, we have received the case diary.
Lodge. So basic allegation, Lordship, is the incident occurred, Lordship, at the time of at night, Lordship, 2 a.m.
In the night.
Lordship. And if Lordship go by the affair at page 12. Yeah, Lordship, also I, Lordship, submitted that the son of this informant, Lordship, who is a habitual offender, Lordship. More than, Lordship, 30-40 cases is pending in different courts against him.
Son of the informant.
Yes, son of the informant, yes.
Who is
the victim? Yeah. At least to be victim, Lordship.
Achha.
So, Lordship,
On the day of occurrence, Lordship will see the affair. They have narrated a very, Lordship, concocted story. Because at the night at 2 a.m., no one will be, Lordship, ambushing to attack someone, and whether, Lordship, he went to informing this person that I am going somewhere, I will come late. So this cannot be, Lordship, predict, because might be, Lordship, there are some gangs. He is the members of a gang, Lordship. Might be there are some, Lordship, dispute between the members of the gang, and accordingly, Lordship, some incident took place. But we are, Lordship, this petitioner in item number 2029, we are the neighbor, Lordship. We are not in talking terms since last few years because of this conduct, Lordship, conduct of the son of the informant. Since, Lordship, every moment police come searching him in a home, and as well as different cases is pending on, all are murder case and robbery case. So, Lordship, we are not in talking terms with this person since last few years. So the day of occurrence, Lordship, see the incident happened at 2 a.m. And at 2 a.m., if Lordship allow me to read the affair, the person of father of the victim, yes, I'm reading the affair, Lordship. With due respect, I beg to state that in the night of 24/1/26 at about 8:30 p.m., my only son Anjan Das, along with his friend, went to see Makh Mela at Subankata. And while my son did not turn home, I was passing the vigil night. In the meantime, at around 2 a.m., I heard halla outside the door of my house. I went out and saw a young man pushing the motorcycle towards my house. When I asked the young man what was the fight about, then he answered someone were trying to brutally kill a person. I asked again who was fighting. Then the young man said that it was Ravi. At that moment, I turned on my torchlight and saw my only son Anjan Das being confronted on his way back near my village under the leadership of Bihuti Pathak, along with the Ravindra Das and two other persons were attempting to kill him. At that moment, I screamed to save my only son. My only son Anjan Das made every possible effort to save his life. When even then Vibhuti Pathak attacked and again threatened to kill him, I moved forward and saw my son was lying unconscious in blood in a critical condition. Vibhuti Pathak, Ravindra Das, along with two other persons who attempt to murder my son, fled the scene. Immediately, with the help of local people, I took him to the local hospital called Ravi Boro Civil Hospital. It is worth mentioning that the local hospital informed us that since his condition is extremely grave and critical, my son must be referred to GMCS today as per the doctor's advice. We are taking him there. So this is the version of the informant, Lordship. So basically the incidents happened at 2 a.m. Whether, Lordship, this person, the son of the informant, he went out, Lordship, informing the other person that I am going somewhere. I will back in the 2 p.m., 2 a.m. It cannot be predicted, Lordship, because he was a dacoit, professionally he is a dacoit. So might be some incident.
That is not the submission, my lord. Whether he is dacoit or not, that is different thing, my lord.
Yes.
He may submit his case, my lord.
Yes.
But it is whether he is dacoit or not, that is not in the even the city of my lord. But he may argue on his
What is
point.
in the CG, Lordship, I am not aware. But my submission is that, Lordship, might be he was beaten some person by some person, but we are not there. At 2 a.m., Lordship, we have nothing to, Lordship, nothing business to waiting for at 2 a.m. So how, Lordship, they can predict that we are waiting at 2 a.m. Whether this person went out, Lordship, informing us that I am going somewhere, I will back at 2 a.m. This is not the case, Lordship, because we are only the personal grasp of or with us because we are not talking terms. As such, Lordship, as a personal grasp, he has lost, and the person who was pushing the bike, he was not named in the affair. While, Lordship, who was waiting at 2 a.m. to push the bike, that person might be, Lordship, come to the end of this investigation. Whether this person was arrested police and whether this person was named by this informant at night 2 a.m. might definitely, Lordship, that person be local person. At 2 a.m. no one will be waiting to, Lordship, save someone. Definitely he will be a local person or neighbor of this incident. So I am not aware, Lordship, what is in the CD. Let my learned friend submit what is in the CD and medical report, Lordship, what the medical report says.
First of all, my lord, already my colleague has already read out, my lord, statement of the complainant, my lord, informant, where he said that, my lord, he is in his torchlight, he has identified the accused person. Both the accused person are Vibhuti Pathak and Ravindra Das, my lord. It was identified. And my lord, regarding the medical report, my lord, here, the medical report is here, my lord. It was previous, my lord. Previous injury, head injury is there, my lord. And regarding the, my lord, we are, if we are vote for the my lord, statement of the independent witness, my lord, lordship. Already lordship has come, but they cannot deny that they are not present at this at that time, my lord, from the statement of the witnesses.
If at 2 p.m.
That
also
is-
some person will there, lordship, there might be some, lordship, definitely there will be something there. If at 2 a.m. also someone was waiting to give their statement that we have saw the incident, then definitely there will be there.
This Ravindra, one of the accused asked her that come.
My lord, both of the accused person called when lordship, all of them come together, my lord, in the vehicle, my lord. After the incident, again call him, my lord, that driver, my lord. They said that we are in trouble, my lord. We can be rescued from here, my lord. Then that person came.
And then they disclosed.
Undisclosed. That is. Next page, my lord, victim, my lord, statement, my lord, his statement, my lord.
Not remember.
Thereafter, earlier page, my lord, some photographs, on photographs, and medical report. He was initially admitted in GMCH. Thereafter, it was transferred to the higher hospital.
See, Mr. Kalita,
We are not disputing also. We are not disputing the incident also. Might be someone was there also who has beaten this person. We are not disputing that. Only thing that we are not present at that. No, what was all business also at 2 a.m. in the road lodge? That also only because of
coming from that Mela.
we did not go to the Mela lodge. We are at home.
That's what the witnesses.
That is their statement lodge.
That was the witnesses said.
Yeah. That is what I'm saying, lodge. If everything has been lodge, already discovered, statement has been recorded. Let the person be faced the trial lodge. It will be proven trial. What is our lodge whether it is detention is necessary lodge? Since they have already recorded all the statements of witnesses. Only it is whether we were at that time
was
lodge.
so grievous.
Yes.
That the victim now is not in a state to remember anything. So grievous injury.
I am not denying lordship. Might be there or something, but we were not at all lordship there. Our only lordship, the affair has been lost because we were not in talking terms. We had some personal grievance.
Is there any other?
My lord.
No other.
My lord.
Apart from this independent witness.
My lord. At night, my lord, that is my lord. But
So-
others also, my lord, mother, father, all of their statements are there.
The family member, they will definitely depose against us. So on the basis of the statement of the
And I also prayed for my lord, custody required. They said that their custody is required. Other persons are yet to be arrested.
Other persons, sir?
There may be some other persons, accused person.
Two more.
okay, let us appear lordship. We will definitely cooperate with the investigation lordship. And let us establish whether we were at that time lordship, we were at home or we went to lordship Mela. At 2 a.m. lordship, I do not know who has given statement against us at 2 a.m.
Oh,
Who was he? Who was he is doing? Yes, that is, I am not saying anything against the city, but I am saying only who is the person who is giving statement against us at 2 a.m. He has seen us. So that is the lordship basic.
No, he was the person with whom your petitioners were going in fact.
I was
After
lordship.
after Mela.
I was at home lordship. I don't know lordship who is the person. I'm not aware lordship, but
No. After Mela, you were accompanied with that person. Because in the Mela, obviously there was a Mela.
Yes.
So after this Mela, they were returning.
But lordship,
At
as
that
per my
point of time,
instructions,
this
yes.
kind of incident had happened.
As per my instructions,
Obviously, due to some
yes.
This altercation was there, and at that heat of the moment, the incident had occurred.
Yes.
Which reveals.
This lordship, we may be lordship allowed to go on bail. Lordship, we are ready to cooperate. Let the lordship actual culprit be recovered lordship from the.
No, you are the actual culprit. What?
We are not at all lordship. Let us establish our case lordship before the police lordship. Then police will confirm whether we are involved.
Check the
So lordship, for a humble submission lordship, we may allow to lordship appear in the IO.
Mr. Sharma, the learned it's an application section. So and so CD receipt. It is submitted by Mr. Kalita, the learned counsel for the petition that these petition sites. And there it is submitted that the victim is a person against whom about 30-40 cases, including some Gauhati and murder cases, are also pending, and for which these two petitioners are also not in a talking terms, with the victim. But is submitted at the night of 2 a.m. No one will come and attack the accused victim without any reason. However, both the petitioners are ready and willing to extend their cooperation in further investigation case if they are granted with the privilege of defense. Mr. Sharma, the learned PP submitted this that the medical report is also received from along with the case diary, from it is seen that the victim sustained previous head injury, and for which he also lost partial memory. He further submitted that from the statement of the witnesses as well as one of the independent witnesses, it is seen that sufficient incriminating evidence has been brought against these two petitioners who were stated to be involved in the arrest of Mr. Sharma, according to his objection in allowing in granting bail to the presentation. Hearing this submission made by the for both sides. Considering the matrix in the case study and overall circumstances of this case, I find that one opportunity may be given to the present petitioners to appear before the IO and to cooperate in the investigation. In view of this, both the petitioners are hereby provided with interim protection. He'll receive the updated case diary according to this provided. Okay, will be some interim protection. Go and
Lordship, definitely. We will cooperate, lordship, fully cooperate.
List on 25-3 for updated case diary, CDB data.
Lordship, I'm deeply obliged, lordship.
My lord, 30, my lord, 30, 13 March. After the
25-3.
Lordship, obliged.
26 and 27.
Two are different cases, your lordship.
Different cases?
Different.
Oh, I thought the same.
No.
Different, no?
This one is your lordship. Your lordship will kindly come to page 15.
No,
The
first
Bharani
26, start with 26.
26. This is 26, your lord. Samsad Alam.
CD received here.
Lords, this case, your lordship. May I read your lordship? সম্মানপূর্বক বিনীত নিবেদন এই যে আজিৰ পৰা
Where is the effect?
15, your lordship, ভাৰ্নিকুলাৰ your lordship. আজিৰ পৰা প্ৰায় 2-2.5 বছৰ আগতে শমছেদ আলমৰ লগত মোৰ চিনাকি হয় আৰু পাছলৈ প্ৰেমৰ সম্পৰ্ক হয়। প্ৰেমৰ পইণ্ট আমি দুই জালুকবাৰী এটা ভাড়া ঘৰত একেলগে থাকিবলৈ লওঁ। এনে অৱস্থাৰ পৰা তাৰ গৰ্ভৱতী হওঁ আৰু সি মোক নানা প্ৰলোভন দি অমনস্থ কৰিবলৈ হয়। তাৰ কিছুদিনৰ পিছত আমি দুয়ো কোৰ্ট মেৰেজ কৰাৰ সিদ্ধান্ত লওঁ, কিন্তু কোৰ্ট মেৰেজ কৰাৰ আগদিনাই
সি ভাড়া ঘৰৰ পৰা পলায়ন কৰে মই বহু হিচাপ কৰিও বিচাৰ কৰিও সংশোধনক বিচাৰি নাপালো মই আনবা জানিব কৈছে সি ৰাজস্থানৰ পৰা মোৰ পৰা আঁতৰি কৰবাত আত্মগোপন কৰি আছে সেয়েহে মোৰ জীৱন ধ্বংস now this is the affair your lord now knowing fully well for 2.5 years she stayed with me your lordship and then your lordship she maybe your lordship there is some dispute and ultimately he has decided not to marry her but that will probably not bring him within the ambit of your lordship section 69 your lordship and there is no date nothing your lordship when the incident took place of this the allegation your lordship then can be based on this your lordship a person can be your lordship charged with criminal liability your lordship that too your lordship will see the sections your lordship 69 and 89 of BNS.
Sixty-nine is okay. What is 89?
89 is your lordship will kindly come to 89 is causing miscarriage without woman's consent your lordship. These are the two.
She alleged about her miscarriage.
Yes. And there is nothing in the FIR when that took place. It's a vague FIR, your lordship. Recent judgments are there, your lordship, from the apex court, your lordship. That these kind of things, your lordship, knowing fully well the consequences you are living with me without marrying, marriage, your lordship, and then your lordship, some dispute cropped up and you come up with the FIR. That is probably
On
in
good faith, she was with you.
lordship.
On good faith, she was with you. You assured her to marry, na?
That your lordship, that cannot be your lordship. Our social system is not like that. Without marriage, your lordship, prohibition, your lordship, is not socially permitted, your lordship. And knowing fully well that this may happen, she should have been very careful, your lordship. And I have, your lordship, after getting interim bail, I have appeared, your lordship. My statement has also been recorded, your lordship. On 15 November, your lordship, my statement has been recorded, your lordship. Good afternoon.
Oh, she was carrying twin pregnancy,
Minor.
na?
If that is there, your lordship, then this allegation will be false. That if twin pregnancies is carrying, your lordship, then your lordship গৰ্ভ নষ্ট কৰিবলৈ বাধ্য কৰে. That allegation will go, your lordship. Both cannot stand together.
No. At the time of ultrasound, it was
Found.
that she is carrying twin pregnancy.
Yes, thereafter that is
Anyway, what are the other? He appeared?
my lord. Appeared, my lord. Here before that, my lord, in 183, my lord, chess category implicated what is happening, my lord.
The implications.
My lord. And allegation of abortion is also there, my lord. And rupees 1 lakh rupees also taken from her, my lord. That allegation of the in 183 statement, my lord. And from the
Why she gave 1 lakh rupees?
Initially 80,000 taken on pretext of different thousand, my lord. And thereafter 20,000, my lord. That is their her statement, my lord. In 183 statement. And my lord, lordship, my kindly very last IO note, my lord. He has appeared, my lord, but he has failed to produce sufficient bail bond, my lord. That's why it was again called on, my lord, after 1 week, my lord. But
he could not produce
at that time, my lord.
That part I don't have any instruction, my lord.
He was asked to appear again with
my lord. But thereafter, she did not update, my lord. His statement is not there, but when he is appearing, that information is there.
His statement is also not here.
Not there. But from the IO note, it reflects that he has appeared and said so and so, my lord. That is there.
Then your lordships, may grant me some time, I will take instruction on that, Your Lordship. And in that case, he will go again appear, Your Lord.
Twenty-six to Mr. S. Waterford, the landed council petition. Also heard Mr. B. Sharma, the landed edition with the appeal on behalf of this is an application with section so and so in connection with proceedings of petition. However, at the time of hearing of this case, it is submitted by Mr. Sharma that there is a no IO wherein it is from it is seen that after obtaining the order of interim pre-arrest bail, the petitioner appeared before the IO, but due to non-availability of the bailier, he was asked to appear before the police station on subsequent date with bailier. But CD is not updated, and the last entry of this case diary is of 28/11/2025. And the statement of the present petitioner is also not available in the case. Mr. Sharma, accordingly submitted that updated case diary may be copied. However, it is submitted by Mr. Waterford that as per his instruction, the petitioner appeared before the IO after obtaining the order of interference. Next, in view of this, let the updated case diary be called for, and the petitioner and the IO is hereby directed to furnish the statement of the accused petitioner if already recorded, and further direction to the petitioner to appear before the IO within 7 days from the date of order and to record his statement with failure if not earlier recorded. With the above observation, let the case be listed on when it can be listed.
Final 23rd, my lord,
23rd of March, to and so, with the direction for furnishing the updated case diary. Interim be extended till next. Okay, your interim be extended. You just
Lord.
inquire the matter.
Lord,
Whether he
I will take instruction.
because note is there, he appeared before the IO, no doubt about it. But thereafter, his statement is recorded, not recorded, is
Lord.
not there.
I will take instruction. 27 Eurostat CD was called for.
23rd.
20, no, 27.
Yes, what is
Or
27?
27. My lord, here CD received, my lord, but medical report not received, my lord, injury report, my lord. They are interim.
You need the injury report here. Injury report is
Not available.
not available.
No.
It was registered under 118 also. No?
Lord.
Minus
118.
81
118.
Otherwise, CD is updated.
CD.
So you are going to retain or you are returning back?
Minus
Better to return back, I think.
minus.
Hard Mr. Export food, Ilan also for the petition also. Hard Mr. Bishop, Ilan petitions, VP, bring on the opportunity. It is submitted by Mr. Sharma that CD received, but the injury report is not available in the case diary, which will be required for passing the bail order. In view of this, let the CD be returned calling for updated one along with the medical report, along with the medical. When it can be listed then?
My lord, 26, my lord.
26/3.
My lord.
To be listed on 26/3, so and so. Interim be extended till next date.
Who will return the case?
Yes, return.
Interim maybe.
You be extending your interim till 26/3.
Deeply obliged. Deeply obliged.
No, bail if and wait. Let's keep. Oh, you got admission. Which activities?
For admission, item number 18. May it please your lordship, may this matter be adjourned for today?
Your lordship, this has been going on for a long time. they have they have obtained stay since 2022 and it's 26. If your lordship peruse the order sheet, this has been going on and on, your lordship. We have mentioned this matter for early disposal, your lordship, because your lordship, something has to be done, your lordship.
Lordship, example today,
Your
we
lordship,
not
they have
received
made
any-
similar prayers earlier to your lordship, several occasions, your lordship, they have made, and they said this is the last time. And again, your lordship, same prayer has been made by
Your Lordship, on last date 17/11/2025, they have taken time, Your Lordship. We have not objected to that, Your Lordship. However, now they're objecting, we do not mind. Let the matter be-
17/11/2025.
Let the matter be fixed on the next week, if possible, Your Lordship. Next week, immediately, Your Lordship. No problem with that, Your Lordship. Just accommodate us for a week, Your Lordship, where to obtain some instructions.
No, so there's nothing to obtain instruction, your lordship. This is a matter, they have challenged something, your lordship, whether, and they have obtained in stay, whether your lordship, this will go on in the High Court or your lordship will
A
demand
date
it.
may be fixed, Your Lordship, in that matter. No problem with that, Your Lordship.
We see there are in several occasions the adjournments was taken.
Yes, sir.
Yes. Earlier, it was taken, adjournment was
On
taken.
one occasion, your lordship, we may have taken, your lordship.
That we.
This time, also, we had made mention, we have put effort to get this matter listed, your lordship. And again, they will come and your lordship take time, your lordship. It's not done.
A date may be fixed in that regard, Your
But
Lordship.
what is your problem today?
Lordship,
Why you
there's,
need the adjournment?
Lordship, there are some instructions we need to take from the client. Just a week, next week, any date next week, Your Lordship.
There's
We'll be-
nothing about instruction, your lordship.
That
This
would-
is a
that-
matter, this is a matter criminal petition. They have filed a criminal petition challenging the proceeding in the lower court. They have said that this civil case is going on against the.
There are multiplicity of proceedings regarding that, Your Lordship,
Yeah.
and civil cases going on in
Yes,
this matter.
and
Your Lordship.
civil case is not against the respondent, it is against the respondent's husband, your lordship. So this has to be done with the respondent, your lordship. Respondent, the
But
matter
all of
with
the
respondent has to be
transactions
different,
but-
different thing. It's a totally different thing. Your lordship, this is a matter, your lordship, simple matter, where I have accused them of committing a crime under section 420 of IPC, your lordship. Now, whether your lordship, this matter, your lordship, they have said that this is civil in nature since a civil case is going on against my husband.
In course of- in the same
me
course of
and-
transaction,
me
your
and
lordship.
her husband, your lordship, me and her husband. Now, this is a different matter where your lordship, certain transaction has happened between the petitioner and me, your lordship. So, your lordship, now I have said that
And
there.
as per you, there is no connection that. if
No,
it is
nothing,
supposed
your
to-
lordship. That is George Rahman Chaudhary, the husband of the petitioner. She is Momina Khatun. So it is a completely different matter, your lordship.
It's
And
in
your
all
lordship-
in one course of transaction, Your Lordship. That's we need
Your
to.
lordship, that has to be seen by the trial court, your lordship. Your lordship, the high court will not see on just factual things, your lordship. This honorable court will only see whether, your lordship, there is something with regard to law, your lordship. Whether prima facie this is a petition that needs to be closed, your lordship. Prima facie, there is an element under section 420 IPC, your lordship. They have obtained money fraudulently, your lordship. What does section?
Yes, I can.
Your Lordship.
See, in that case, if it is 1 week, suppose,
Your Lordship, today is Friday. Matter may be fixed on Thursday. 3 and 4 are holidays. Maybe in Thursday, no problem then, Your Lordship. If it's too urgent, then Monday also, Your Lordship. If that is so.
Lordship, your lordship knows, your lordship. We have to, your lordship, we don't get, your lordship, the matter listed by making mention, your lordship. After a long time, your lordship, we have got this matter listed, your lordship.
list is already there on 22nd.
Then on
It's a
5th, Your
big
Lordship.
list is there.
5th, Your Lordship.
5th, many matters are there. We may not be accommodate you on 5th. Now 6th is some personal problem. 7th I'm going outside. So if 6th is there somehow, if we cannot pass the order, then it may again create problem. In that case, at best on 9th.
Your lordship, from 9th, I will not be available, your lordship.
9 to?
9 to, still Eid al-Fitr.
Oh.
1920, I will not be. Thank you. So your lordship,
9th you will be available, no?
9th, I might be here.
You might
And
be.
your lordship, no problem with that.
If tomorrow would have been an open day, your lordship, court day, then would have taken it tomorrow.
Can it be taken up on Monday? One matter, your lordship supplement. The matter can be taken
Oh,
up.
Monday, in a case, in fact, Monday, the list is already there. There is supplementary, maybe there, but the list is a quite big list, in fact. Monday possible, no more. Should not be, I think. Food matters as
Your lordship, then
well. Let it be on 9th then.
your lordship, but your lordship, then an observation may be made that no further time will be granted.
Sure.
No,
Sure.
sure.
Very request. Your good name?
T. Chetri, your lordship.
And a request made by Council Mr. C. Chetri for the response. It might raise that. However, and you are Mr.
I who said.
I Hussein. However, Mr. I Hussein raised women objection in allowing the granting the act, and it is stated that, and it is submitted that in many occasions the case has been adjourned and the other side is enjoying the interim order since 27/6/2020. Considering the submission made by learning council for both sides, let the matter be listed on 9/3/2025, asking both the parties to proceed with the hearing without any further adjournment. List.
Interim
Nine.
order may be
Interim
continued.
interim be continued till next.
Much obliged.
Your lordship.
Which is the other side?
Other side is not present, my lord.
Mr. Hawk and M. Hawk as M. Borua, Mr. M. Hawk actually. So state is also a party here.
State is not a party. It's an NIA case, my lord.
Oh, it poor party. It was jano. Oh. It is a case of NI.
NIA case, my lord. There's initially the petitioner was convicted, sentenced to pay a fine of rupees 1 lakh, 17 lakhs, my lord. Appeal was preferred, appeal was dismissed. Against that, this revision has been filed. Now already he is on previous bail and has come up for admission. Records have also come, but they are not.
Records also.
Well, we'll fix it after 2 or 3 weeks, my lord.
Because state is most probably a formal party, even if they
In our petition, we have not made state a party.
Oh, the order is saying so. No, that's why I'm just confused whether this is the case record or not. Because heard Mr. So and so, Dilan Kansipuri as well as Mr. K.K. Parashar. Order no hoy. Your first order is of 2024.
24, my lord. Perhaps, my lord. State is not a party otherwise.
State is not the party, most probably there is some
Hello.
mistake in the typing the order because it was the first order.
Yes.
That is 21/10/2024.
24.
Since then, the record was called for and you are already on previous bill. Na?
My lord. There's I we had filed an I has been
is there.
disposed of.
Some mistake is done. We also heard Mr. S. Abbas regarding the petition. None appears on call for the respondent. Don't name of Mr. M. Hawkins reflected in the cause list. I mean, we have received the case record.
Case records have been
Case record has already been received. However, due to absence of the counsel for the respondent, matter could not be heard today. The matter be accordingly listed.
After 3 weeks, my lord.
3 weeks, you fix a date here or?
We are on interim, my lord. So as per your lordship's convenience, my lord.
The interim is making no sense because you are on bail only.
My lord.
27 will be too late for you or what?
No, my lord, we have no urgency, my lord. We are on bail. There is no urgency for us, my lord. Urgency would be for them, my lord. Even if your lordship does not fix a date, my lord. After
Oh,
3
this
weeks,
should more good than. Anyway, we're fixing it on 27.
my lord. 27th of March, my lord.
27th of March.
I'm deeply.
27 today is 27. We cannot figure on February.
My lord.
Not in April.
Not in April.
March.
I'm deeply okay.
How no correct? Oh. Do take it. Okay, no. We not correct.
Number 20.
Yes, item number 10.
May I please, your lordship?
Mm.
Your
Yes.
lordship, this is a 528 application under BNSS.
Yes, 528 application.
Under BNSS, challenging the final order FR, which has been accepted by order dated 30/9/2023 by the additional CGM Nagaon, your lordship. This is a very technical case, and we are
Against the order acceptance.
acceptance of FR, your lordship.
Acha.
We are the complainants here. However, notice was not served to us. There were 4 complaints in the FIR, your lordship. Notice was served only to complainant number 1, and further during investigation of the IO, there is an affidavit to an effect wherein there are signs of only 2%. One sign of missing is there, your lordship. So on technical ground, we are impugning the final order, your lordship. Order accepting the final order.
No, but how many accused persons were there? Oh no, you are the complainant.
I'm the complainant here, your lordship.
So you
There are
have
4
received
complainants here. So we are not given a
received the
notice.
notice?
Not notice. The case may be remanded back to learned CGM and notice may be served upon us. The FIR is at page number 12 is the FIR, your lordship. Page number 12.
It's a misappropriation case.
Yes, your lordship. 409 and 420, your lordship. And the case being cognizable, non-bailable, non-compoundable has been compromised by means of an affidavit.
Well, before whom the affidavit was sworn?
Before the notary public. No,
No, notary public is it was furnished before the court or before the
IO.
Before the IO.
In the
Where
affidavit,
is the FR note on the
26. The impugn order is at page number 26, your lordship.
Twenty-six.
26.
So here one one order is also there.
Your Lordship.
In the so I did not get any so. The information, not information, should be informant anyway. Informant by petition number 4955 stated that he oblique she does not have any objection if the FR is accepted.
Your
So
Lordship.
on that very day, whether you have filed any petition numbered as 4955.
The petition was not filed by me. It was filed by informant number 1, Your Lordship. I am informant number 3 and 4. In fact, notice was not given to
How
me.
many informants are there?
4 informants are there, Your Lordship.
4 informants.
4 informants are there. The FIR relates to fraud in examination form fill-up, Your Lordship. And there are parents, they are the persons are the parents of the children. Page number 12 is the FIR.
20?
Page number 12 is the
Yeah.
FIR page. Vernacular is there.
So complainant. From where you are saying that you are 4 complainants? It's not here.
Your Lordship, at page number 12, iti apuna bisakhi, number 1 LTI of Sahidullah, Moinul Haq, Pita Mito Abdul Muttalib,
Moinul Haq.
RTI of Jorina Khatun, Sami Moinul Haq, RTI of Khudeza Khatun, Sami Nazir Haq, Nazir Ali.
These are all 4.
Is there 4? It is written there in the FIR that relating to fraud of form fill-up examination.
Relating fraud.
Fraud.
Now, who are you? You are the informant. Which informant you are?
I'm informant number 3 and 4, Zarina Khatun and Khudeza Khatun.
So 2 are here now.
2 are there. 2 petitioners are there.
We have received
LCR has been received.
this year. I say. It will. Watch.
Your Lordship, while
And as per your information, who is the person who appeared before the learned trial court below with a petition that he or she has no objection?
only one informant, Mr. Sahidullah.
Only one informant, Mr. Sahid.
Muhammad Sahidullah. Sorry. And our statements were also not being recorded, Your Lordship. At page number 20 in the final report part, page number 20, Your Lordship. Column number 1, it is Muhammad Sahidullah, Moinul Haq, Ikramul Islam, but there is no mention of the 2 petitioners here, Your Lordship, while they being the informant. So this is the abuse of process of law.
They were not known as an
Witnesses. And lastly, Your Lordship, there is one more submission. In the affidavit at page number 24, vernacular, page number 24, the affidavit submitted before the IO, it is written that Ami Muhammad Muhammad Sahidullah, Muhammad and Moinul Haq. It is been addressed as we, but at page number 25, only signature of one person is there, Your Lordship. It is a high degree of fraud. 24 is addressed as 2 person. At 25, there is a signature of only 1 person, Your Lordship.
This is the affidavit, compromise.
The compromise affidavit submitted before the IO. So my submissions.
So keeping you all 3 petitioners behind dark, only 1 petitioner did all this.
Yes.
I mean, 1 complainant did.
1 complainant. Only on technical ground we are there before this court, Your Lordship.
I am appearing for
The
the.
state is also there.
State is also.
No, you can submit, yes.
I am appearing for the respondent number 2 and 3, the accused persons in the case. Herein, I would like to draw your lordship attention to page number 12 again, lordship. Page number 12 says Azhar Kari in vernacular, Muhammad Sahidullah. Only one person is named here. And here, to support him, other persons might have signed. But they have not been considered from the inception as informant. And to strengthen my submission, I would like to draw your lordship attention to page number 17, lordship. Page number 17 is the final report. Page number 17, therein at para 8, complainant / informant details. MD Sahidullah, son of so-and-so, so-and-so. So throughout, this person, in a complaint or in a Azhar, it may be signed by lots of people. So it is not technically feasible that all the persons should be treated as informant, because FIR means the first informant who knows the first hand about the matter. So out of all these, someone will be first. So to inform about any cognizable offense, any information by any person, a single person is enough. So these persons might have corroborated or might have supported the affidavit, but the police during the investigation did not consider them to be the informant. Rather, they would have been considered as witnesses, as has been done in case of Mainul Haq. The number two is Mainul Haq. And now my learned friend has referred to a compromise affidavit, wherein purportedly two persons have been named, but one did not sign. So under such circumstances, if any complaint should have come or any petition should have filed, that to have been filed by Mainul Haq, because his name has been used here.
Who is Mainul?
Mainul Haq is number 2 in the
Informant number 2.
in the FIR. There is no such term as informant number 1 or 2. Informant and the witnesses. One will be considered to be informant. And herein, while filing the FIR, when the FIR was written, at the starting, Lordship Azhar Kari, Sahidullah, had this person been informant, their name would have come here as 2, 3, 4, and 5, etc. Prior to filing of this FIR, just to strengthen their point, some people have signed. And interestingly, so these two ladies have no locus to challenge this before this honorable court. Even then, had any objection or clause or any irregularity allegedly has been found, or any mistake done by the learned magistrate, this person, including this Mainul Haq, could have filed a protest petition there. There is provision in the CRPC as well as in the BNSS, but they did not do it.
They were not aware.
In the LCR also,
they are not even required to be aware, because on record, when the charge sheet was filed, in the charge sheet, Sadullah or the Sahidullah is the informant. In the FIR, if we go through the form of FIR in the record LCR, we will find that this person has been recognized as the informant. Others might have been recorded as witness. Why they are not recorded as witness, that is known to the police or to the party. But on record, Sahidullah is the informant. And the learned court below rightly called this informant to the court for notice. He appeared, he filed a petition, that is also on record. This Sahidullah filed a petition, and on the basis of this petition, the honorable court closed the matter, accepted the FIR. Now, as my learned friend has alleged that there is misuse of power or abuse of the power to invoke the power under section 528, is missing lot. The learned court below has bona fide act. He issued a notice. There is no pleading that the court below did not issue notice to the informant. They may say they are one or two of the informant, but they are not informant in the record. And in the criminal jurisprudence, as your lordship better know, that there is only one informant. We may come, 20, 30, 50 people may come together to file a complaint. Whether all these person can be included in one column as the informant? No, the answer is no. So Sahidullah was the informant. If the other persons, these three persons are aggrieved by this action, they could have easily filed a petition to recall the order or to register the case or proceed with the case recording their statement under section.
They did not get the scope of recalling.
Yes, when they come to know, from that point of time, the limitation will start. If any, they could have easily approached the court below with a petition that we are also informant, we have not been informed. Then in such event, if their petition would have been rejected, then 528.
Till their appearance, the case has already disposed of.
No,
FIR has already been accepted.
Your Lordship,
on the facts and circumstances, in some cases it happens that if we file a FIR before the police did not take action or files FIR, we can approach the court below, concerned court, to take cognizance under such sections under the provision of section 210 of BNSS or under section 223 of BNSS. So then also they may be heard, the case may be decided, the accused may be summoned. And herein this is not the case that these accused persons were left scot-free. One of the accused person was arrested, the respondent number 3, he was behind the bar for 22 days, and the respondent number 2 got interim bail from this Honorable High Court that was made absolute subsequently. So investigation was there. This Sahidullah, in this affidavit of compromise, has clearly stated that there was some misconception on his part, misconception of fact, or under the instigation of some other person, he have filed this petition. He has not stated that I and 3 others have filed. And police also, on their wisdom, could have called him or said him that you bring these people. But on record, only Sahidullah is the informant. So where the learned magistrate has committed the mistake, where? In which manner? That to be identified. That to be placed before this honorable court to invoke this jurisdiction under section 5P. Serious abuse of process of law should be there. This is usual practice. Usual practice on, say rightly or wrongly, the police files an FIR, the court issues notice, the informant comes. If he objects, the case goes on. If he doesn't object, then it is closed. This is the general practice. How this magistrate, learned magistrate, could know that there are lots of informants, there are lots of witnesses? There is no chance, because the learned magistrate will go by record. In the charge sheet says that Sahidullah is the informant. In the FIR format, except Sahidullah, no name is recorded there. In the list of witness, the name of Mainul Haq is there. So how these other people can come? So my submission is that these 2 petitioners have no locus. Because if we go through the CD in the case record, TCR, we will find that relevant witnesses, the guardian of the students from whom allegedly the extra amount was taken, have been examined by the police under section 161. These 2 ladies has not been examined. So if they are informant, they would have gone to police to record their statement. They did not do it. Even after knowing about this matter, they did not approach the court below with any appropriate petition. Rather, they choose to come to this honorable court. Had there been rejection of their petition, then they could have come with revision or criminal petition, whatever. But herein, they could not substantiate that the learned magistrate caused error in justice or there is abuse of process of law. So this petition deserves to be dismissed, because prima facie there is no locus of these 2 ladies. And there is no explanation how they are connected to this case. There are lots of people, lots of guardians in the school. Why these 2 ladies only? Others would have come. Because this is a matter of general concern. This is a serious offense. I admit, 409 is a serious offense. So the other person, other concerned guardian and parents of the school could have come. to resist this, to object this, but these two ladies. So there is something behind this action.
Your Lordship,
of this
from
two
the
ladies.
language of
This
the
is not bona fide.
from the language of the FIR, it is in it is addressed as we, Your Lordship. All the time it has been addressed as we. And the informant number 2 as Moinul Haq, he is an educated person. He has signed rightly in the FIR, Your Lordship. In the literature of the FIR, is সন্মানপূৰ্বক বিনীত নিবেদন এই যে উক্ত আসামী দুইজন কালিয়াডিঙ্গা হাইস্কুল মাদ্ৰাছাৰ অধ্যক্ষ আৰু সহ শিক্ষক হয়। আসামী দুইজন পৰীক্ষাৰ ফৰ্ম ফিল আপৰ লগত আমাৰ সকলো ছাত্ৰ ছাত্ৰীৰ পৰা ফৰ্ম যিমান পাৰে সিমান টকা লৈ আছে। কাবাৰ পৰা 20 to 50, কাবাৰ পৰা 20 to 50, কাবাৰ 20 to 50, 17, 50, 20, 50 এনেদৰে আসামী দুইজনে লৈ আসামী দুজনে টকা লৈ আত্মহত্যা কৰি ৰাখিছে। So, Your Lordship, it has been said as we, and my learned senior said the aspect of informant as only one in criminal process. Well, Lordship, considering the facts of the case, and since this is a problem related to students, and a lot of students are suffering, Your Lordship, proper investigation may be ordered by this court. And as per even in the final report part, our petitioner have signed the FIR. They were not called for the witnesses, Your Lordship. At the very preliminary stages, they have been prejudicial, Your Lordship. Since, Your Lordship, on technical grounds,
Yes, but who is here?
notice.
The FIR itself, Lordship, there are 4 persons, informant. Yes, it is also true that if in the format only one person's name is entry, and subsequent for 3 persons' name, it is that there is no any provision explained. But when a case is investigated, all those persons who are named, who are the complainant, their views are required. Their complainants, their statements are required. In that case, Lordship, if you go by that affidavit, the 2 persons have given the affidavit, and 2 persons without taking the consent of other 2 persons, without taking that FIR final report has been submitted, and one in the name of informant that has been sent. For the interest of justice, to my understanding, Lordship, it should go to all of them, because only one person's consent, when other 2 persons has not given any consent, only 2 persons has given consent. Only to those persons FIR has been notice has been sent. Other persons' view is also required, to my understanding. What I have. For the ends of justice, Lordship, it is given.
Yes. It's 20 grade. Please. You're Mr.
A. Iqbal.
Jad Hussain.
Jet. Number 2 and 3, and Mr. Yes, from the body. State respondent. It's then.
Lordship, just a minute. Case 26. Herein, on receipt of the court notice, the informant appeared before the court today stating that he has no objection on perusal of CDCR. So, herein, while passing this order, this compromise was not taken into consideration by the Honorable Court. So, whether this is right, wrong, I am not on that. The Honorable Court, as per the procedure, called him, who is on record. He appeared and filed a petition that is in record, I think. So, this is done in a process. And by now, the respondent number 1 has got retired. All the things has been seized, all the things has been examined. So there remains nothing.
It's 28 PLS. prohibited the learned citizen now accepting the valid report in connection with Julia PS filed in connection with Julia PS case number 426 submitted by Mr. Iqbal that initially one FIR was lost before Julia police station. By four numbers of complainant, including present two petition before the Church police station with some allegation of misappropriation of money by two accused persons, namely Motiur Rahman and Khalilur Rahman, in the name form fill up in the name of form fill up examination, who was discharging their duties in the school in the Kaliadinga, 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 Kaliadanga Madrasa High School as headmaster and assistant teacher. After the investigation of this case, the IO filed the final report on the basis of an compromise deed, which was executed by one of the informant, namely
Sahidul.
And one, namely one Sahidul and one Hawk, wherein it is stated that due to some misunderstanding, the FIR was lost. But surprisingly, in the said compromise deed, the other two complainants of the informant were not informed about the compromise deed, and more surprisingly, the compromise deed is signed by only one Sahidul. Two, it is stated to be sworn by two persons of the complainants, namely Hassan Akib, Sahidullah, and one more. Next, Mr. Iqbal further submitted that this is a case of very serious in nature, wherein the FIR has been submitted by the IO and the learned trial court below without issuing any notice to the present petitioner had or disposed of the matter, considering the submission and the petition filed by one Sahidullah, the FIR was accepted. It's order dated. It's order dated. The 9/2022, wherein it seems that the one petition was also filed by the informant, being numbered as 4955, stating that he has no objection in accepting the further submitted that in spite of the four complainants in the FIR, the notice was issued only to one Shahidul, and these two petitioners never received any notice from the learned trial court below to hesitate the matter or to hesitate the matter or to file any protest petition against the acceptance of accordingly, it is submitted by Mr. Also, he submitted that 2, the names of two petitioners, no, two complainants were shown in the list of witnesses, but two of them are not even named as a witnesses in the FR, and their statements are also not recorded by police before filing, at the time of investigation or before filing. Mr. Iqbal accordingly submitted there are technical errors, and while accepting the effort filed by the submitted by the IO, and hence he submitted that the matter may be remanded back with a direction to the learned trial court below to issue notice to all the complainants and to pass necessary order after examining of the recording the statement of all the witnesses as provided. Mr. Hussain, and Mr. Hussain, the learning counsel preparing for the response number 2 and 3, who were the accused persons, the alleged in the case, has submitted that the learned trial court below and rightly passed the order considering all the aspects of the case. Full stop. He submitted that the FIR, from the FIR itself, it is seen that the complaint was lodged by only by one Shahidul, Shahidul, and the other three persons were signed only as a witnesses, only to strengthen the case of the complainant Shahidul, which was lodged before the jury of jurisdiction. From the notes of from the form of the FIR also, it's seen the name of the complainant is written as Shahidul, and the other persons were cited as a witness. Accordingly, he submitted that the learned trial court will considering the name of the informant, who is stated to be one Shahidul, the notice was issued, which was duly served in, and the informant Shahidul also accordingly appeared before the IO with a petition stating that he has no objection in accepting the, and in that view only and after complying all this provision, the effort has been accepted by the Senate and court bill. It is committed for setting aside the order of acceptance passed by C. If it is submitted that there may be a compromise petition before the IO at the time of investigation, wherein admittedly only one person, namely Shahidul, had put his impression to the compromise. It is stated to be sworn by two persons, including one woman. But he submitted that the compromise petition has no connection with the order passed by the learned trial court below, and the order was passed basically relying on the statement of the complainant and the petition filed by him, and the no objection petition filed by the petition. Mr. Hussain further submitted that these two petitioners could have approached the learned trial court below with a protest petition when it was within their knowledge about the acceptance of the without approaching the learned trial court with the present petition has been filed in 528 PNSS, which is not maintainable and liable to be dismissed. expert, Mr. Lockwood internet petition be submitted in this regard. That it is a fact that the name of the informant of the complainant is written as one Shahidul. But from the FIR itself is seen that 4 persons put their signatures as the complainant, and hence before passing any order of acceptance, the other complainant could have already, the notice could have issued to the other complainants to raise their objection, if any, before accepting the act. Accordingly, it is submitted that matter may be remanded back to the pass appropriate form after hearing the submissions. Okay, I'll pass the order. I have recorded your submission.
DPO.
I did read in the and sound. Alia. Itu like did everything.
ECR received, but it is incomplete because Lord, the CD part has not come. Only some 2-3 pages has come. CD part has not.
You need the CD.
CD part has not come.
CD is required.
Not CD is irrelevant, Lordship.
Irrelevant.
Irrelevant. They are time. Response number 1 is the main person, Lordship. State is only formal
You need
party.
the CD also. Scan copy. Why you need this?
State is formal party, Lordship. We have no grievance against the state, Lordship.
But it is out of a FIR, no?
Non-FIR.
It is what?
Defamation case, Lordship. Police submitted report as non-FIR. Then court took the cognizance, which is not permissible under the law. Limited issue, Lordship. Very limited issue, Lordship. And under 196 CRPC, Lordship, totally bar, Lordship. Police cannot, Lordship, submit any report.
Mr. Lockwood, they basically raised some issue on the law points.
Law, purely law, single.
To get prepared because state is the otherwise it's a party. So as the FIR is there and it's an but FIR was lost or no FIR was lost?
FIR was received, Lordship, then report was submitted to the magistrate, Lordship.
What kind of report?
Report, Lordship, that the cognizance may be taken under 500 IPC. And law is well settled that police should refuse the FIR. And as per section...
The question is that now definitely FIR on the basis of this this defamation case cannot be registered. That is understood. Now police only submitted the report.
That cannot be done also, Lordship, as per apex court judgment.
On the basis of report, what has been done by the trial court? It has been registered.
To cognizance, Lord.
But on the basis of one government registered case or the CR?
CR.
Then
But,
how can you say now these things?
But
Okay,
in his
blocker. Though state is a formal party, but there are requirement of your submission also.
No.
Going to hear
I will
it
go through
today.
it. Lordship, fix it and any date or something.
Pardon?
Any date, Lordship.
And what kind of interim you are enjoying?
Interim proceeding.
Stay is day.
Proceeding is state law.
State.
State law.
Then you go through the no. Just one thing I just want to ask. He is rightly submitted that CD may not be so relevant because it is a case on basis of friends. But otherwise, I want to submit one thing. Obviously, this defamation cannot be based on FIR or it cannot be registered directly by police. It cannot be. But here in this case, I don't know the about part from his submission. I'm saying that it was filed on as is the non-cox, so police made an inquiry by them, and it was report was submitted before this. And on the basis of that,
Whether that
only
report
the-
is valid or not, that much.
that much, and then on the basis of that, but CD may be required in that context as to whether there was any inquiry.
If today it
These
is not
things-
disposing of, then CD may be called for in the meantime. That part, CD part may be called for because it is not, as it is not disposing of.
No, I'm not going to dispose this today.
In the meantime, CD may be called for, CD part may be called for. Registry will call for the CD.
In the 21, the name of some other councils are also been reflected. Who are they?
They are for the informant, Lordship. They are not appearing for last 3 occasions, Lordship.
Probably their interest is gone.
Because state may not be so interested party, but this informant is the interested party.
Informant is the aggrieved party, Lordship, interested party. They filed wakalatnama. They entered appearance, but for last 3 occasions, they are not appearing.
They are not appearing.
Last 3 occasions. As on today.
Normally, what happens, Lordship, in defamation cases, a company against defamation cases, what happens? At the heat of the moment, they lost the affairs. In most of the cases, Lordship.
Yes.
And even in complaint cases, then when it is filing as a complaint case or civil suit also, Lordship, then also at the end, now no one comes. Because their first and foremost was to show the public that, and this is a public, probably this
Political.
is a political party.
Both.
To show the people, the public, that they are doing something against their religion. That's what is.
But this is also politically.
Political.
But when there is a law point involved, also that may be looked into also.
Yes.
Because that is the
It is
question.
what? Muhammad Badruddin Jamal.
Azman.
Oh, Ajmal. Oh,
Against Kamalaksha Purkasta. He is also
Kamalaksha Purkasta.
He is also the political Lordship.
Now, Kamalaksha Purkasta is in which party now?
Now
Congress.
but not officially joined BJP. He is MLA, Lordship, in South Korea, North Korea.
Oh, acha. Then to definitely you are rightly pointed out there. At this stage,
At this stage now election
When
is
there is a,
knocking
as
the
the
door.
proceeding has been initiated by the trial court, so to visit that proceeding, that law point has to come out.
No.
So Lordship may kind of fix it any day.
And election is also knocking the door. That is why they may not be, Lordship. Interim may continue, a long date may be given, Lordship. After election.
Long date, Lordship, even we will also forget the case, Lordship. End of the March,
No one appeared for the other respondents. Last occasion also, the other respondents were not represented. Right?
After visit.
Is submitted to the for that. The scan copy of the dossier has already been received. It is not is to be directed to call for case data. In view of this, the registry is directed to call for scan copy of the case data, and issue reminder may be issued to that record, directing the trial court to furnish the scan copy of the dossier in connection with this case. List the matter accordingly when it can be listed.
Last part of April, Lordship, election.
After election, Lordship. Otherwise, again.
Then in that case, it will be listed after 4 weeks.
No.
Then it will
Then-
come after 4 weeks as an effective.
Fine.
Interim because
May kindly fix a date because Lordship, otherwise we will also will come
Forget.
in again, Lordship, because
because month of April, end of April, we are not giving any dates till now.
Sure.
So let
March-
it be after 4 weeks, as in it will be listed as on a date to be. Otherwise, we are continuing your interim.
May I please, Lordship? My Lord,
Petition for Zimmer of the vehicle, my lord. My vehicle was, my lord, seized on
Yes,
14.
what is the position? Have you received the report and all?
Yes. In the meantime, my lord, 3 persons are not involved in this case, my lord. They filed one anticipatory bail application and they have been, my lord, granted anticipatory bail and they have already appeared. And their statement also have been recorded, my lord.
Why you need all this?
Because, my lord, I am not the accused. The owner of the vehicle is not accused in the case, my lord. This is actually, my lord, MBA Act violation, my lord. Kindly see the order, my lord. After perusal of the case diary, this order was passed. So, further custody of the vehicle may not be required.
Yeah, a report was called for, and that report they could not produce. They have written a letter to us that due to some official duty, they could not.
I think, my
provide
lord,
us the
no report is required. Kindly see the order, my lord. Kindly see.
The order.
Order.
Yeah.
The bail or MBA Act violation.
No, what is the FIR about?
My lord, FIR, my lord, kindly see page 14, my lord. Actually, my lord, violation of MBA Act, my lord. It has been already observed. But criminal color has been given, my lord. Page 14.
This is regarding his bail application.
Yes.
Only because of that bail application.
What is the further detention is required? Because my vehicle was, my lord, seized on 14/1, more than, my lord, 1.5 months, my lord.
And apart from that, lordship, it was
So, my lord, this is a simple case, my lord. Kindly see.
It was on the basis of a ACD that investigated till that day. Further investigation, after further investigation, what has come out, we do not know. Let the report be covered.
What investigation will be carried out, man? Kindly see.
One accident took place.
Submitting. The question is that if we go by the FIR also, it's not a case that it was basically mostly an accident took place.
Yes.
An accident took place wherein these things happen and there's some allegation brought against someone and the FIR is lost.
My lord.
Now, in that connection, whether this will be required or not, it's a matter to be seen. Anyway, what the police says, it is the report is not here. Was there any earlier order you have annexed here?
Yes, my lord. Police raised objection because at that time, my lord, that these 3 persons were not, my lord, appearing before the police, my lord. Because, my lord, there is an
Where is the
apprehension, my lord.
order? Order of protection.
My lord, page 29. Now, my lord, they have already appeared. This objection was made because, my lord, they were not appearing, my lord. Thereafter, my lord, they have been granted anticipatory bail. They appeared and their statement recorded. So nothing, my lord, required. This order was passed on 28/1. My lord, thereafter, my lord, these 3 persons appeared after getting anticipatory bail, my lord. So further, my lord, custody.
Your custody was since when?
My lord, on 14/1.
This year only?
Yes, my lord, 14/1, January, my lord. More than, my lord, 1.5 month, my lord.
Yes, sir.
This is an accident case. Kindly see the order, my lord.
But lordship, as I heard, lordship, can you go through page 14 is the Azhar, na?
Yes, yes.
It is not very, it is simply an accident case. Here some altercation took place. Some criminal act has been done.
But that has not been observed in the, my lord, order, my lord.
No, we are not on order. But the question is that basically one accident took place.
Yes.
And thereafter the incident had happened. What is the criminal incident? After the dashing with the car or motorcycle where thereafter some altercation and this kind of assault and all are also there. Question is basically on that basis whether the vehicle will be required. Now the question is, as we call for the report, better to receive the report when it can be given.
Well, my lord, the accused persons have been released. What is the, my lord, necessity of my vehicle, my lord? Here. 29.
20?
29.
And my lord, this owner of the vehicle, my lord, is not the accused in this case also, my lord. This is
Who
simple
was
case,
driving the vehicle?
my lord.
Who was driving the vehicle?
My lord, among those three persons, my lord, who have been granted
Why you
anticipatory
let
bail.
the vehicle
Because, my lord,
drive them?
they are all my lord relatives, my lord, they took my vehicle, my lord. That is why.
Yes, talk for anything.
This was rejected on 28/1.
You want to deport or what?
I leave it to Lordship.
Persons have been released, my lord.
No, we are not concerned with the person. Concerned with whether the vehicle will be required by the death.
More than one
should provide the
and a half
report.
month has gone.
It is also there is no any involvement of vehicle in any way.
Right.
Otherwise, in any other.
It's nothing that.
Even if the occurrence took place, even if some criminal act has been done, then the persons will be the persons involved in that criminal act. They will be.
I mean, the vehicle was seized because at that time the vehicle was there to there was a case.
Most
When
of the
the
times it
accident took
depends
place,
that someone he hit someone.
take subsequent thing. Say this. Also, yes.
No.
They done it. They accident application. BNSS. It's a order dated 2801 at 6 Intima petition number 486 of arising out of particular case number 0 public 2026 281 127 117 74 3 packet of 5 PNS whereby Jimma of the vehicle that is the Swift Desire bearing registration number AS01 EV 8248 seized in connection with the aforesaid PS case was revoked. It is certain that Mr. Lockwood that Bio could be report because for as he is otherwise busy. The secretary returned a constitutional petition submitted in this regard that in the case the accused is accused in this case the petitioner is not an accused and he is the registered owner of the said vehicle. At the time of rejection of the earlier bail application, the case was at the initial stage of investigation, and the other petitioners were also to be arrested by the accused by the police. However, during the pendency of the present application, the accused persons have already moved an anticipatory bail application, which is also granted by this court. Invite its order dated 20/02/2026 passed in AB 335 of 2026 with an observation that it is the matter only related to traffic road traffic accident. Mr. Sikter accordingly submitted that the further custody of the vehicle is not at all required. Rather, there will be probability of damage of the vehicle if it is kept in the open space of the police station. And that Mr. Lockwood denied additional PP submitted in this report that though from the FIR it is seen that basically it was a case of accident, but there are some other criminal incrimination against the accused persons in the said FIR. Accordingly, he submitted that the vehicle may be required for further custody for the purpose of investigation. Next, we're hearing the submission made by the Superior Court this year, and the order was by the learned trial court below by rejecting the prayer for Jim. Next, it is seen that the type of rejection of the earlier petition, the IO had submitted a report stating that the further custody of the vehicle may be required for the purpose of investigation, as it was at a very initial stage. But here it is seen that the vehicle is in custody, the police personnel of the IO. Since when it is in custody?
14-1. 14-1.
14-1. It is more than 1.5 months. Further, from the FIR, of the FIR, ingredients of the FIR, it is seen that it was basically basically it was a accident case where subsequently some allegations has been brought against the occupant of the vehicle, who stated, who alleged to have been assaulted, who alleged to be wherein the informant side was alleged to have been assaulted by the accused. But considering the nature of the offense alleged against the petitioner, wherein alleged against the petitioner, I find that further custody of the vehicle may not be required for the purpose of also, as stated by the counsel for the petitioner, he is not an accused in this case. Considering all these aspects of the case, nature of the considering all these aspects, nature of the offense alleged against, and nature of the offense as stated in the FI of the case, I find that further custody of the vehicle may not be required for the purpose of investigation. In view of this, considering the view of the owner, first in case of Sundar by Ambatul accident, I think this code is opinion that the vehicle bearing registration number Swift Desire AS01 EV 8248 can be given Chima to the present petition after verifying all the documents and also verifying regarding regarding the ownership of the vehicle. In view of this, the order passed by the students is citizen. The petitioner is further directed to file an appropriate application for Jim, which will be considered by the learned trial court below, and the order of Jimma will be accordingly passed by verifying all the documents and ownership with the observation.
Highly obliged. Highly obliged.
The matter is public.
Yes, 43.
Yes, Lordship.
No, you
Lordship,
mentioned something in the morning hours, no?
Yes, Lordship.
Yes, what is it?
Lordship, I am appearing on behalf of the respondent number 2, Lordship.
Respondent number 2.
Respondent number 2, and I came to know this particular case from the Gauhati High Court portal that the petitioner filed this instant criminal petition for quashing of an affair filed by me before the Roha police station, Lordship. Lordship, the
But
address.
your petition is for what?
I did not finally petition, Lordship. I am appearing on the respondent number.
Oh, sorry. You are respondent here.
Respondent number.
So what you have come to know, they have filed another petition.
No, Lordship. The address has been properly not given in the portal. Therefore, the service has not been completed. And I did not get any copy of the copy of this instant case, Lordship.
But you have appeared.
Yes, Lordship.
Yes. Huh? Pardon?
Petitioner side is not.
No, it's okay. Now what he is submitting?
Yes, that got that.
Copy of the petition. And then your not name is not in the portal and all you are submitting.
Lordship, my name has been reflected.
Your name is already reflected.
Yes, Lordship.
So you are saying that your name is not
No.
I mean, in the
Address of the respondent number 2 has not been properly given in the portal, so the service has not been completed till today.
but you have appeared on what basis? You have appeared for the respondent.
Yes, Lord.
On the one hand, you are saying that the service is not completed as the proper address is not there. But on what basis you have appeared now?
Lordship, from the Guwahati High Court portal, I came to know that this petition has been filed by the petitioner for quashing of my FIR.
Whatever notice is not yet served.
Yes, Lord. Lordship, direction may be given to them to provide a copy to me, Lordship.
Otherwise, you are going to represent.
Yes, Lordship.
Okay, then why are you making so complicated? You have not provided with the copy.
Yes, Lordship.
In the morning hours, it could have been clarified. You waited till up to 4. I could not go through here something saying portal and all that. I thought that better to call for at the time. Anyway, state is number 1 and you are now representing one Priyani Malik.
Yes,
Sharma.
Lordship.
We will provide you the copy. You are Mr.
D. Burman, Lordship.
Part Mr. D. Burman, the learned counsel, appearing for the respondent number 2. Also part Mr. Yes, Lawford, the learned additional PP, appearing on behalf of state respondent. No one has represented the petitioner today. However, it is submitted by Mr. Burman that as the name and address of the respondent number 2 is not showing correctly in the portal, Guwahati High Court portal. The notice is not yet served before. No, sorry, it's not named. It was showing to by us is not proper. It's not proper. The notice is not proper. Notice is not yet served to the respondent number 2. However, coming to know about the pendency of this case from the High Court website portal, he entered into evidence on behalf of it. However, till date, he has not received a copy of the criminal petition. In view of this, petitioner is hereby directed to provide the copy to the petitioner and put to the respondent number. Please the matter accordingly after. The matter accordingly after 2 weeks as on a date to be expected. We are
Kindly fix it if possible, Lordship.
why you were interested? Your respondent 2 weeks. We are listing it after 2 weeks.
Deeply obliged, Lordship.
No, already. No. Him. One. Call for the matter according to 2 weeks as an date.
Maybe, Your Lordship, this is an appeal against conviction along with a fresh IA for suspension of sentence.
In the previous occasion, your lordships, it was directed that the instructions may be taken regarding the service of notice, your lordship.
I'm applying for
You are
number
appearing.
2.
Response number.
Yes.
Nice. What was the term of conviction?
Your lordship, the appellant here has been convicted under section 451, 376 and 511 of the IPC.
What is the term of conviction?
10 years, your lordship.
10 years. So you want to file something. And you also fine?
My lord, we don't have the copy of the IM.
State has already received the copy of the IR or not yet? You have received. We have received it this year also. So you can submit and we will giving direction to the others.
They can, if they can provide us a copy. I could get it.
You are Mr.
J. Kumar.
J. Karim.
J. Kumar.
Oh, sorry, J. Heard Mr. J. Kumar did not considering for the appellant. Also heard Mr. P.S. Rapport did not considering for the state. Mr. Q. Yogan did not considering. Is submitted by Mr. Khan that they till date they have not provided with a copy of the interlocutory application. In view of this, the applicant is hereby directed to provide copy of the petition to both the state respondent as well as its. Further, it is submitted by Mr. Lockhart that they will further some more time is sought for by the planet additional PP for submitting their written petition. How many weeks you need it at least?
Within 2 weeks.
2 weeks. You want any fixed date here?
Yes, your lordship. If possible, by the end of March, your lordship.
Freeze it. Otherwise, also you say if Australia appeal is already admitted and that apart the CD case record is already there. So next date we may go for the hearing also. It doesn't matter. Your petitioner is in behind the bar since when? Your appellant?
Your lordship,
Judgment was passed on which date?
2/5/2023, your lordship. So,
23.
yes.
We'll see.
Obliged.
It is appealed by state. The other side did not appear, no?
Notice whether served or not.
Notice, I don't know. Notice. Oh, no, no. This has come for the first time, I think.
Then notice will go. This is the first.
It's heard Mr. P.S. Doctor Delaney petition. This is an application grant of leave to file an appeal against the acquittal as mandated under section 378(4) Code of Criminal Procedure. Now under section corresponding to section 4194 of BNSS. Issue notice to the respondent. Through speed post and usual process. State appellant will take necessary steps. This the matter accordingly after 3 weeks as on a date. What was the case? Was acquittal was there? Nature of it?
Yeah. So is there, lordship, that is probably child marriage is there.
Oh. There we find very difficulty when child marriage is also there. If we go by the reference, what will happen is happen. Obviously, section 6 also will definitely, section 4 will rather 6 to 11.
They are married, their children are there.
That is the practical aspect is there. But it may be a check in the other cases. Yes, 35.
45.
Met please your lordship,
Was a delay. How many days?
227 days delay.
27 days. Yes, state is the only party here or other side?
Yes, I am for
Oh,
repetition.
no, Momtaz Begum is the, no? We have to issue notice because 40 days is okay, but you are 235 or 135?
227 days.
People
And they have made us only. It is the only party.
Get a one.
Only given it.
Even days delay. Then 20.
When you're delayed.
220. 220. Yes.
Revision it.
About it to equals 8 equals 9. Even this. Directly. Why I'm asking,
we are the only party,
earlier
so-
one earlier application they withdrawn in fact.
Yes, Lord.
There the delay was 134 days. Now I don't know, note he is saying 227 days. The cost title says otherwise.
Otherwise, it is against conviction, so we are the only party. State is the only party here.
State should be only party, but there is one more party. Ought to have been one party, but there is one more party. It is fine.
The themselves has made their case complicated. It was okay.
Now, what is the case of? Nothing is here. What is the case? Your conviction under which section?
498A of the 34 IPC.
498A.
Yes.
State is the only respondent, or you made respondent number 2 also?
Only respondent.
Here too, one more is there. Beleni. Here, one is there. You see, I don't know what is the correction and all.
It is our earlier petition probably.
Earlier. Now she is made party.
Yes.
She is made party. Okay, we are issuing notice. State is already there. Issue notice to the other side.
Yes.
The respondent. And as you have submitted, you have submitted rightly because 227 was there, but it was a calculation wherefrom it is seen that it is not 227 but 135, maybe 136 days. Because there was a liberty. Liberty was granted to you while withdrawing the case. So that calculation is already there. Okay. So not 227 but 135. Anyway, we issue notice. 2 weeks as an date.
That is lordship. Hearing 152 days delay, lordship.
What is it?
152.
152 days.
It's good.
As it faster.
It's
138.
Oh, it is 138.
Yes, your lordship.
Oh,
It's a
then
negotiable.
notice
State
has
is
to-
only the final battle.
Yes. In that case, notice has to go. I thought that state is the party, then we could have disposed it today itself, but it's not. Okay, hard, Mr. You are Mr.
KK
KK Deka, Dilani Council. Also heard Mr. B.S. Crawford, Dilani Additional PP appearing for the state number 1. This is an application under section 5 of the limitation appearing for continuation of period 152 days in filing the connected revision petition against the order passed in criminal appeal number 9 of the 2023. 9 of the passed by Learned Session Judge Pokraj. Reaffirming the conviction of the petitioner under section 1. Issue notice to the respondent to speak immediate comment. State respondent for list matter only. After we cannot fix a date after 2 weeks, we are fixing.
Fix Lordship.
As on a date to fix by 2 weeks. You take steps today or by next week, you take steps.
Highly Lordship. But
May it please your lordship, there's a delay of 343 days and the conviction is under section 10 POCSO Act, your lordship.
RMS M.K. Brown, the learned counsel for the petition. Petitioner, sorry, applicant appellate, also part Mr. P.S. for the learned petitioner PP appearing on status. Same order. It order to judgment and order say 27/12/2024 passed by learned special judge POCSO. Again, liquid. Yet I say like cost it. And the delay days we say 343 days. Issue notice query. In that process, he has to be a POCSO case through Office of the Registry. No, through public Office of the Public Prosecutor, routed through the Office of the Registry. To take steps, it will be go through the Office of the Public Prosecutor.
Your lordship, I'm the legal aid counsel.
Oh, you're legal aid?
Yes,
Oh, it's
sir.
not here as a legal aid. And legal aid counsel. Legal aid, no?
Yes, sir.
You're doing well in the other cases I have heard you. So I thought that this is your case, private case. Anyway.
Much of it.
3 weeks for you. 3 weeks.
Yes, your lordship. Lordship, this is an IA for continuation of delay of 117 days, lordship.
117.
In connection with the
Yes,
criminal
state is
appeal.
the only party
No,
or
your lordship, no, your lordship, there are respondent number 2 to 15, lordship.
2 to 15?
Yes, your lordship. For enhancement of punishment, lordship.
For enhancement of punishment?
Yes, your lordship. Lordship,
I mean, in appellate stage, your punishment was enhanced or what?
no, your lordship, I am here the appellant, but there are 2 cases, lordship, 2 FIR. The respondents, they are convicted of under section 147, 320, 41 for 3 months imprisonment, and that imprisonment should run concurrently. So, lordship, according to their offense, the punishment is very less. So, this appeal is for enhancement of punishment of the respondents, lordship.
So under which section you have filed this appeal?
Lordship, this is an IA, lordship.
No, this is an I. Otherwise, the
Lordship,
appeal is filed.
413.
Huh?
413.
413. BNS.
Yes, your lordship. Lordship, may I say the grounds of delay, lordship? Lordship, I am sentenced with 10 years of jail, lordship. I am imprisoned with 10 years of jail, lordship. And but the respondents only 3 months, lordship.
No, but you are the victim or who are you?
Lordship, in this case, lordship, in this sessions case 623, I am the victim, and in their case, They have
They
pretended me
told you
as
that
not
there are two
victim.
cross
Yes,
cases.
yes, Your Lordship.
No, but whatever, under 413, the victim can file. So you are the victim
Yes,
in
Your-
this case.
Yes, Your Lordship.
In this case, he is victim. He is victim, and in
That case, they are the victims, Lordship.
they are the victims.
Now you are convicted with 10 years.
Yes, Your Lordship.
So where are you now?
Lordship, I was in jail. I got released on Lordship 4/11/2025.
After your release, you have filed this.
Yes, Your Lordship.
So that's why delay is.
Yes, Your Lordship.
This will go.
Lordship, notice may be issued.
This to effect they has to. You are MS?
A Hussain.
I don't know what I'm at. Third MS A Hussain, the counsel for the petition. Yes. Application for condonation of delay of 1 month 7 days in filing to criminal against the impugn judgment and order. Dated 25/0 passed by learning additional session C charge in sessions case number 06 in connection with Katigora CS case number 394 of the 9. Issue notice to the to all the responses to stakeholders and campus. Comment notice is required to be sent state responsibility. We are listing it after 3 weeks as on a date to be fixed by the registry.
Please, Your Lordship. This is an IA for vacation of the ad interim order. On the last occasion, notice was issued to respondent number 2. TCR was called for, but same was not received yet. Direction may be
I think both the TCR as well as the service is still awaited.
Yes, Your Lordship.
This is also available.
Yes, you have already taken steps.
Yes, Your Lordship.
You are MS?
L. Thakur appearing on behalf of AK Das.
L?
L. Thakur.
Thakur. RMS L. Thakur appearing on behalf of
AK Das.
Mr. AK Das, Counsel for the petition. From the office note, it reveals that the service as well as TCR is still awaited. TCR as well as the service is still awaited for the service be awaited for till next date of listing. Estimate according to the date. Now just tell me one thing. This application is for vacation of.
Yes,
vacation of the interim order.
Yes,
so they are not appearing in that case. I mean, question is that they filing this application for vacation of the interim order. Interim order was definitely passed not in favor of you but favor of some others, I think, respondent.
Yes.
So they are not appearing in that case. Why? Wait a moment. Can you follow Mr. Lockford? I have not gone through the record, but you are saying that this is the petition wherein you pray for vacation of the interim order.
Yes.
So definitely interim order was not in favor of you, but favor of some other or the respondent.
Yes.
So in which case they are not appearing there?
They are appearing.
Then why you are waiting for service? I don't know that. The original case, where is the original case? You don't have any idea.
Criminal petition 143 of 2024.
No, this is criminal petition 143.
Today was for IA 123 of 2024.
They are seeking the proceeding.
To quash the criminal proceeding.
Proceeding of the DV.
TV.
Now, what is the IA then?
Quash.
But you, yes, I say now she is submitting that this petition is for against the interim protection or the interim order or vacation of. That's what I'm asking, if it is the interim
One
vacation
equity order is helping pass favor of them. So that they have come.
Yes. So if the order is in favor of them, they should be here only. Why it's waited for service? Can you follow me?
Lordship.
On one hand, you are saying that your petition is for vacation of the interim order. Passed not in favor of you, but in favor of some other, I don't know, respondent maybe.
Respondent number.
So if they are appearing in the original case, they could have, you could have taken directly received the petition itself, the copy of the petition itself. So why we are waiting for